Right. We'll call to order tonight's meeting. My first on a roll call. District one, Mr. Jeffrey Lee.
Present.
District two, Dr. Samuel Valme.
Present.
District three, is it Mrs. or Dr. Diane?
No, Diane Easter.
Miss Diana Easter.
Here, present.
District four, myself, Felicia Harrell, present. District five, Mr. Desmond McLean, the former chair, has resigned his position. Tax Commissioner's appointee, Mr. Lee Kelly,
Present.
Mr. Nicholas Craig,
Present.
and the Clerk of Superior Court selected alternate member, Dr. Erica Pike.
Here.
And we still have a vacant position as one of the alternates as well. Okay. So anyone wants to make a motion to approve the meeting minutes from 6/10/2025?
Make a motion. Second.
All in favor of approving the meetings from 6/10/25? Say aye.
Aye.
I make a motion to amend tonight's agenda to add item M. To vote for a new vice chair of the Board of Ethics, Henry County Board of Ethics. I make a motion. Does anyone second that motion?
Second.
Fantastic. I'm sorry. I need to make an amendment also to tonight's agenda to move item M to after item B and prior to item C.
Madam Chair, before you make a motion to amend, we need to vote on the last motion.
I apologize. I make a motion the second, all in favor of adding item M to the agenda as an amendment tonight after item B and prior to item C. All in favor? Aye. Thank you. All right. So let's get to voting. Do I need to make another motion to begin the voting process? I make a motion to begin the voting or nomination of the voting process, nominee, and the voting process for a new vice chair. Can I get a second for that?
I'll second.
All in favor? And would anyone like to nominate a new?
I nominate myself.
Anyone else? I'm gonna nominate Jeffrey Lee. Are you okay with that? Let's hold a vote. All in favor of Dr. Samuel Valme as the new vice chair, all in favor, say aye. All in favor of Dr. or Mr. Jeffrey Lee. So all in favor of Dr. Samuel Valme as the vice chair, new vice chair, all in favor? Can we get a show of hands?
Aye.
Aye.
The alternate cannot vote.
Yeah, so,
Who cannot vote?
so we have a yes from, Miss Diane Easter. We have a yes from Mr. Nicholas Craig. We have a yes from Mr. Lee Kelly. So those are they wanted me to name the name. She couldn't see who said yes. And of course, Dr. Valme agreed as well. All in favor of Mr. Jeffrey Lee as the new vice chair? Aye. Just myself and Mr. Jeffrey Lee. So it looks like we have a new vice chair as Mr. Dr. Samuel Valme. Moving on to item C, general updates by the ethics officer.
We have a few general updates, a very lengthy agenda tonight, so I did summarize the updates a little bit more than usual. Just as an appeal update, did get a final decision on Otis Key versus Philip Sisk. If you all remember at the last meeting, I reported we were waiting on the judge actually issued the order. I'm pleased to announce that we technically failed on that appeal. The judge adopted the argument that I made before her that one of the conditions precedent to any appeal is that the individual has to pay their fine. And the fine was not paid, so as a result, the court contacted me and asked me to draft a proposed order dismissing the appeal. I provided that to the court. And as of July 2nd, 2025, that appeal is officially dismissed. So that case will now be closed. Questions on that? Training update, we have 692 people that have been trained in person, and 781 that have been virtually trained. I did do what I consider almost like a mid audit. So we paused the trainings in June just to kind of see where we are. I realized in doing that I typically tell you all how many we have left, but that's not a good way to really keep account of everything because the employee numbers don't ever change. Sometimes they're up, sometimes they're down. So honestly, I'm going forward, I'm just going to start telling you all where we are based on the number of employees that we have at that time. So this is kind of where we are, which is still over half of the last employee count that we had, which is 2176, the last employee count that we had. So now what we do going forward is we'll see which specific departments are lacking training, and then we'll schedule some more in-person trainings to see how we can get those accomplished as well. In addition, the county manager did reach out to me. She asked me to provide her with a list personally of any of her executive leadership team that has not done training. So he's really invested to make sure that all of her executive team ensures not only that they got trained, but that they're making sure their workers get trained. So that's kind of where we are now. I can also report, I don't have a slide board, but we now have all commissioners that have attended their training and concluded their training. Our police number went down to 9. Last meeting, I think former Chair McLean asked a question about 2 because he was saying, well, wasn't it 2 at one point in time? I had to go back and check because I was a little confused about why he would think it was 2, but that was fire at one point in time, but we had 2 that kept lingering from month to month, but they have resolved that issue. Now it's just police. We've already contacted them with about their 9. One is on medical leave, one is on military leave. And the other ones, I believe they indicated that they have been trained. We think it's through new employee orientation. So we're just working on trying to figure out why we don't have their list on our roster. Because we still get all of those lists. I still get forms from them too, so I should have their name somewhere, and I don't. Other than that, I met with JP from Parks and Rec. We're still on our way with their training. We have the Transportation Advisory Board that will be trained next week, or the week after next. We have the Parks and Rec Board that will be trained next week. So we're still making good progression. What other questions are?
Just one question for me. Would it be helpful if we're looking at percentages as far as the training, 692 and what percent of the population as far as the employees? Would that be helpful?
That will be a question for you all. Would it be helpful if you all saw it in percentages? I don't have it in percentages. I can tell you the last employee count we had was 2176, and we had a total of 692 and 781. So if you want to see it in a chart form to do percentage, I can, but it'll probably change meeting by meeting because the employee count always goes up and down.
Yeah, but once you do the percentage, you can capture the total versus who's been trained as far as percentage.
The total for that month. I can do it that way. And I typically have some type of chart for you all. The only reason I didn't break it down as detailed as we did last time because our agenda was so lengthy with 7 preliminary hearings that I just tried to summarize kind of. But I'll put the chart back up there next time. And you want the percentage of the overall employees compared to the ones that have been completed versus the ones that are incomplete?
Completed.
Completed. Okay. Any other questions on the training? If not, Chair, or Vice Chair, excuse me, no, Chair, yes, Chair, that's all the general updates.
Item D. Presentation by the ethics officer of probable cause hearing on case 2025 before John Doe versus Carletta Burrell and Benita Harris.
Thank you, Chair. In regards to 2025 EB4 as it relates to jurisdiction, we do have jurisdiction over this case as both individuals are county officials that have been appointed and or elected in some capacity. So we do have personal jurisdiction. According to the complainant indicates that there are essentially violations as it relates to the failure to show impartiality in performing official duties, to the disclosure or use of confidential information, the misuse of position, incompatible interest, engaging in activity prohibited by law, inappropriate conduct by a member of the Board of Commissioners, and a failure to disclose interest. The complainant alleges the following for the board's consideration. The complaint stemmed from the removal of Ms. Harris from this board, Henry County Board of Ethics. The complainant alleges that Ms. Harris committed perjury to the Board of Ethics by stating that the grand jury appointed her, although board member Dr. Pike advised that the grand jury did not interview them. The complainant alleges that Chair Harrell and Ms. Harris had a pre-existing personal relationship prior to Ms. Harris being appointed to the Board of Ethics. The complainant alleges that Ms. Harris represented Chair in an official capacity and formally organized a business together. The complainant also alleges that based on the relationship between Ms. Harris and Ms. Harrell, the Code of Ethics was violated and that Ms. Harris committed perjury while serving on the Board of Ethics. The evidence that I reviewed was evidence that was submitted by the complainant, which included reviewing and watching the special call meeting of May 28, 2025, reviewing the county ordinances, as well as reviewing the meeting minutes. I have included before you a copy of the county ordinance, as well as a copy of the minutes. I did personally watch the video myself in order to kind of inscribe basically what took place at that meeting. Initially, the county attorney came up and charged the board with their responsibilities. According to the county ordinance, there is a board of election. And whenever there's a vacancy for the fifth member, the Board of Commissioners is in charge of filling that vacancy. There became a vacancy as that fifth member, who's also known as the member at large, decided not to continue holding that seat. And because they decided not to continue holding that seat, the Board of Commissioners was charged with filling that seat. Because they had to fill the seat, they called a special meeting on May 28, 2025. That special meeting was publicly displayed so that people will know and the purpose of it. A motion was made by Commissioner Neat Robinson to appoint Ms. Benita Harris. And then the floor was opened up for all nominations. And the only person that made a nomination was Commissioner Robinson. No other nominations was made by any other board members. It was a second vote by Commissioner Lewis. At that point in time, Commissioner Wilson asked that Commissioner Robinson tell them a little bit about the nominee because he was not familiar with her. The county clerk, Ms. Braun, did not receive anything from Ms. Harris in regards to her qualifications. So Commissioner Robinson indicated that some of the background of Ms. Harris talked about her retiring from the CDC and talked about how she would serve fairly and how she believed that she was impartial to all of the elections and things of that nature. At that point in time, Commissioner Harrell advised that she knows Ms. Harris on a personal level. And because she knew her on a personal level, that she was not going to vote and that she was going to abstain and let the other board members make a decision as to whether or not Ms. Harris should be appointed to the Board of Elections. At that point in time, all of the members voted. It was an not unanimous vote. Everybody voted to pass the resolution that appointed Ms. Benita Harris as the next member at large of Henry County's Board of Election. They then did a motion to adopt the resolution. That motion was second, it was passed. Chair Harrell again abstained, said she was abstaining because she knows her on a personal level. And everybody unanimously voted for her to be the next member at large of the Board of Elections. So that is almost the summary of what transpired at that meeting. After reviewing the evidence for probable cause, I have a recommendation for each of the violations. First, as it relates to Chair Harrell, failure to show impartiality in performing official duties. I recommend this for lack of probable cause. If the board needs us to go through any of the definitions of what these things mean, let me know. I know two of our board members have hearing guides in front of them. The next one is disclosure of confidential information. I also recommended lack of probable cause. Misuse of position, I recommended lack of dismissal for lack of probable cause. Incompatible interests, I recommended dismissal for lack of probable cause. Engaging in activity prohibited by law, I recommend a dismissal for lack of probable cause. Inappropriate conduct by a member of the Board of Commissioners, I recommend dismissal for lack of probable cause. And failure to disclose interest, I recommend a dismissal for lack of probable cause. The basis of the recommendations for all of the dismissals for lack of probable cause is on the basis of them not meeting the element of what is considered a code violation. When we're looking at whether or not there has been for lack of a better word, inappropriate conduct, the chair did properly abstain from voting. She did disclose to the board that she has a personal relationship. The board had an opportunity to speak with her or inquire further if they so chose to as to what that personal relationship was. None of them chose to. They all were pleased and satisfied with what they determined to be a good candidate, which was properly brought before the board, and they all voted unanimously to put her in that position.
Question. Time for question?
Sure.
For Dr. Harris, it was noted that Dr. Harris and Chairwoman Harrell had a personal relationship. Did Chairperson Harrell bring to Commissioner Neat Robinson's attention to have her be considered for the position? Have we investigated that option?
I don't know
Okay.
why Commissioner Robinson nominated her. I didn't, at this stage, we don't go that far into it.
And for the definition of personal relationship, is it also noted that Commissioner Neat Robinson also has a personal relationship with Dr. Harris? Because that exists as well.
In the video, Commissioner Robinson specifically indicated that she does not know her on a personal level. That was indicated in the video. Specifically, if I recall correctly, she indicated that I don't know her on a personal level, but I do know of her. I have seen her work within the community. I have seen her participate in community activities, but she indicated she did not know her on a personal.
So when Dr. Harris was on the board and an incident with Neat Robinson's district came up, it was revealed in conversation with Dr. Harris that she called Neat Robinson and talked to her about something in particular. I can't remember the subject that they had a conversation about, but it seemed as if they have a pre-existing relationship that we may not be acknowledging in this process.
That was not disclosed to the Board of Commissioners, and the Board of Commissioners did not inquire about any of the personal relationships. The only thing that Commissioner Wilson inquired about was her background and her qualifications, and to know a little bit about her before they proceeded on voting for her.
So Commissioner Neat Robinson mentioned that the only interaction she's had with Dr. Harris, Benita Harris, is within community activities, but never on a one-on-one personal outside of interaction in public. So does that, so personal relationship, I guess if we can define it, because if they've had personal conversations and know each other on a first name basis, so what they can reach out to each other in that way, then that constitutes a personal relationship between also Commissioner Robinson and Dr. Harris.
Are you saying that you believe, Commissioner Robinson should have his thing in her vote as well?
I am wanting to know more.
Question. So what is the procedures as far as abstaining? What's the purpose of abstaining if you're going to nominate someone within the board? If the board is going to nominate, are you saying they have to abstain if they know the person personally?
I'm not saying that. I'm saying that's the reason she gave for abstaining. So she indicated to the rest of the board that I am abstaining from a vote because I do have a personal relationship with Ms. Harris. That is the reason she gave her board members.
I'm trying to get clarification on procedures for abstaining.
I don't know their procedures. There's no per se legal procedures per se. Now, if we're talking about the code and whether or not she should have abstained from the vote, if we go each one of these one by one, which I suggest we do because that's essentially, different violations, the failure to show impartiality in performing official duties. When we look at what that code specifically says, that code indicates, let me pull it up. By his or her conduct, give reasonable basis for the impression that any person can improperly influence him or his favor in the performance of their official acts, or that he or she is affected unduly by the rank or position of a kinship or association with any person. Because of the abstaining, did not justify making a recommendation from this. If she had not revealed to the board that there was a personal relationship, then I probably would have recommended at least probable cause. But because she revealed that there was a personal relationship and she actually abstained from the vote, I did not recommend probable cause for that specific violation.
So the allegations are narrow in scope to only include Carlotta.
We got into Ms. Harris yet, but for this one, yes. On the disclosure.
However, even though the complainant only includes Chairwoman Carletta Harrell, it still begs more information because by statements given in the meeting, it was said by a particular commissioner that they didn't have a personal relationship. So now, in the scope of it all, one has removed themselves, whether they need to or not, by admitting they have a personal relationship. One maybe not have revealed the full scope of their personal relationship in the process of. And in the process of investigating a complaint, we may have found something more to investigate in addition to the complaint that was submitted because of this complaint.
And then the proper protocol would be for that is for the board to file its own complaint.
Okay.
A separate complaint against that particular commissioner. The disclosure, would you all like to go through the rest of them one by one? Do you feel that's necessary?
Yes, please.
Sure. The disclosure of confidential information. For that particular violation, the code says that you have to disclose or otherwise use confidential information acquired by virtue of a position for another person's private gain. Again, I could not recommend for probable cause on this because we have no facts before that any confidential information was disclosed. One thing we do know is that this nomination was publicly advertised, that the floor was open for all nominations or nominees to be presented, and only one was presented from any of the board members. The next one is misuse of position. This is when you appear on your own behalf or represent, advise, or appear on the behalf, whether paid or unpaid, before any court, legislative, administrative, or quasi judicial board, agency, commission, or committee. Concerning any contract or transaction in which the subject of an official action of Henry County or otherwise attempt to use their position to secure unwarranted privileges or exemption for themselves. Again, I couldn't recommend probable cause for that because Chair Harrell was not using her position to gain another unwarranted position or privilege for herself. Incompatible interest is when you engage or accept employment in a private agency or professional activity when accepting that employment or rendering services is that first to their discharge of your duties. That was not applicable in this situation. Engaging in any activity by a law that is applicable to an individual by virtue of that person being an official or an employee. Again, I could not find any legal basis where there was a violation of law. I looked at the code section. I printed it out for you all to see procedurally. Did they follow the procedure that is written out? And that did take place. Inappropriate conduct by a member of the Board of Commissioners. That is a very broad, as you all know, violation. That's when a member of the Board of Commissioners issue a directive to an employee, threaten to terminate the employment of an employee, threaten to terminate a contract of a employee or vendor, or engage in conduct that is unbecoming of a member of a Board of Commissioners, which we know is very broad. I believe that's something that the complainant said specifically. They believe that Chair Harrell in this act engaged in conduct that was unbecoming. I did not recommend probable cause for that because again, there was a disclosure on the record in full transparency. The rest of the board members had an opportunity to dive deeper into what that personal relationship was or looked like, especially when it comes to elections. There's 5 members. 2 are chosen by the Democrat Party. 2, I believe, are chosen by the Republican Party, and then 1 by the Board of Commissioners. So considering they have a very diverse Board of Commissioners from both parties, if either party wanted to dive more into the nature of the personal relationship they could have, but they did not. So to me, in the process of, I guess, democracy and people having the right to vote and the right to explore, if that's who they chose, then I didn't see that to be inappropriate conduct. And then the last one is the failure to disclose an interest. With this one, an employee has to disclose any interest that they believe be affected by the action of Henry County of another employee, and they have to disclose the nature of the interest and the value of the interest. That did not apply to the facts that we had before us. So for all of those reasons, when it comes to each of those violations, my recommendation was to dismiss for lack of proper cause. The board can determine whether or not you believe that any of these 1, 2, 3, or some of them or all of them could meet probable cause standards. You all can vote on them individually or you can vote on them as a whole. But for this one, it will be only for Chair Harrell.
Right. Would anybody like to make a motion to vote to move forward, or anyone else?
I'll make a motion.
Anyone like to second that motion? All right, so,
We have a vote, Vice Chair.
yes, I'm sorry.
We need a vote. We had a motion in a second.
Yes, but I was gonna ask before we did that vote, are we voting for them to be voted on individually, or would you like to vote as a whole?
That's the question I have as well.
Okay.
Are we voting individually per count, or are we waiting to get the second half of it?
Vote
That's
as a
to the
whole.
board. If the board look at all of them and say we want to vote on all of them and feel one way about all of them, then you can do it, or you can do it individually.
That's not my question. My question is that there's 2 parties. Were you voting for one party and then vote for the second party?
Yes.
Is that clear?
No.
No?
Who are the first and second parties that we're voting?
Chair Harrell and Benita Hurst.
Correct.
I think I know just.
So, you, Dr. Valme made the motion to vote to, a probable cause or to To dismiss probable cause?
Yes.
Dismiss. For all counts or for one count? For each count individually, would you like to vote? Or for all in one vote?
I will do all unless there's a objection to that.
And Mr. Lee, you second that motion
For all,
for all?
for Miss Correa.
Right. So for item 2025 EB4, John Doe versus Commissioner or Chairwoman Carlotta Burrell. All those in favor of dismissing all counts for lack of.
Sorry, one question
Sure.
for the attorney. It says here Carlotta and Bernita Harris. Seems like they're tied together.
So they put two respondents in one form. So it would be, you have to look at them separately for each allegation and individually as different people.
Okay, just want to clarify.
All in favor of dismissing for lack of probable cause for all allegations against Chairperson, Chairwoman, Carlotta Burrell. All in favor?
Aye.
Any opposed? It's unanimous. All right, so
Now we can move on to Ms. Harris. For all of the same counts, my recommendation was to dismiss for probable cause. I will restate my reasoning, which is very similar to Chair Harrell. As it relates to the disclosure of any personal relationship, Ms. Harris was not there, but it was the duty of Chair Harrell as the board member to make the disclosure, and that disclosure was made based on what they heard from another commissioner, which is Commissioner Robinson. The chair or the board ultimately decided to place Ms. Harris in that position. So by deciding to put her in that position, then ultimately I did not find probable cause for her as it relates to that issue. Now, there is a second issue that I want to bring to the board's attention and want you to recall. There was an allegation of perjury that was also made, which could go under a violation of engaging in activity prohibited by law. However, the complainant made the allegation, but perjury is associated with court proceedings under sworn testimony. So under the complainant's allegation, the complainant indicated that perjury was committed to this board, and that is legally impossible because this board is not a board. Well, one, Ms. Harris didn't make a sworn statement. She just sent an email, which is not a sworn statement. And then two, this is not a court. So for that one, I did not find probable cause for engaging in activity prohibited by law.
what constitutes a sworn statement by email?
I think it will have to be in an affidavit form, so it would have to be made in front of a notary.
And as far as a violation, sorry.
No, I'm just making a comment on investigating. It wasn't an official investigation, was it?
No, ma'am, it was an email that was submitted to the board, this board in general, regarding some investigations or some concerns of her as a board member at that time.
It was technically, if we are so we're the board and the matter was brought before the board. And the board decided to remove Dr. Harris from the board. Was that still considered an official proceeding, even though it wasn't a hearing?
When you say official proceeding, are you saying a proceeding of this board?
Right. So if the board acts as a county entity, in a sense, we may need to further investigate if an issue was brought before the board concerning a board member. It was then voted on by the board to remove that board member based on the discovery and understanding, and the email used, doesn't that constitute an official proceeding? Because we had to officially make it a vote. We had to go by the letter of the rules, laws, and procedures in, based on the Board of Ethics and Senate Bill 22. And when the decision was made, that was a decision, official decision made by the board, which was official procedure.
I'm not sure,
Okay,
but I will say, if it was considered an official proceeding, it was not considered a judicial proceeding. And I will read to you all the law when it comes to perjury, which is 161070 OCGA. That's a person to whom lawful oath or affirmation that's typically in front of a notary has been administered, or a person who executes an unsworn declaration commits the offense of perjury when in a judicial proceeding, he or she knowingly and willfully makes a false statement material to the issue or point in question. Based on the statute itself, perjury could not have been committed.
Okay, so is the allegation strictly perjury or a violation of code of ethics?
The complainant said perjury in the complaint. The terminology that they use. And let me just go back, because what I did was I took their words word for word. This is not what I said, this is what they said. And they said complainant alleges that Ms. Harris committed perjury to the Henry County Board of Ethics.
So the terminology is the thing that we're kind of. I think that's what's making it a sticky point, right? Because it seems like we're saying she was in some sort of violation, but it just probably isn't perjury. It could be something else, because it was to.
If I'm looking at,
It's to, the statement was made to the Board of Ethics.
right, if I'm looking at the code itself, taking away the terminology of perjury, I still can't find a violation of a lie. I
so,
can't find where it will fit within a ethical violation of the code of ethics.
So are we talking about Senate Bill 22 or bylaws?
Senate Bill 22.
so based on the procedures and rules for Henry County Board of Ethics, item 8.10, any investigation or hearing. And it basically says any testimony given is considered under oath, right? So that was an investigation, either it wasn't a hearing, however, it was an investigation, and that was her statement in regard to that investigation. Now, personal opinion, I think she misspoke. I think she just misunderstood. I honestly don't think it was willful and intentional. I don't. Based on the reading of that email, I don't. However, because of this complaint, should we basically obviously investigate to make sure we're following the letter of the rules and procedures for this particular board?
Can you direct me, because if I'm not mistaken, the part you may be reading on is in regards to hearings.
It said hearings, it said any investigation or hearing.
Yes, so that is strictly, it came from Senate Bill 22 as it relates to investigation and hearings of complaints.
Yeah.
Not internal procedures. So internal procedures are different. You all govern your procedures of how to remove. Well, the code gives you the authority to remove them based on any reason. So there's no proceeding that has to happen because the code already gives the board authority to remove for any reason with majority vote.
So let me ask as a new board member, is the context of what is in the email, I apologize, I haven't seen it, and it might have been one of those emails. Is that important to the reasoning behind this, I guess, before I can make a decision?
In my opinion, no.
Okay.
Because it still would not constitute the perjury. It wasn't not a judicial proceeding. So no matter what was in there, it is not a sworn statement.
Okay.
And two, even if we take the word perjury out and we're just thinking about the untruthfulness to the board, that was, it gave rise to why the removal took place, but it still wasn't in the context of a proceeding. So if I had, Vice Chair, excuse me,
It's okay.
change my terminology now. Going back to your original question, where I said I'm not really sure if that was a proceeding, I would disagree that it is a proceeding. It's more of an administrative process that took place than a proceeding itself. I think that will be more akin to an employee having to go to HR to answer questions. And then HR making a decision of whether or not to write them up or terminate them.
After an investigation.
Yes, ma'am.
Just making sure, because item 8 says investigations or hearings, but I sign with whatever the board decides.
I have another question. In regards to the last bullet there, it says failure to disclose interest. Can you expound on that as far as the proceeding that went on for the appointment?
Sure. When you say it's found, what would you like to know more about?
You mentioned that there was disclosures, there was people abstained. And she was there, correct? That's what you guys said as well.
Didn't see the audience, so I watched the commissioners' meetings. I can't see who's in the audience. But based on what I could see, it looks like it was a special meeting, and it didn't look like anybody was there but the county attorney and some staff. It did not look like any general public was there.
How long is the meeting and do you have a video available?
It's on YouTube. I can play it up, and I think it's maybe 13 minutes. It's not that long. And I can screen it on here if you would like to see it. Would y'all like me to play it?
Do you have it?
Actually, she's been charged with perjury. Is that one of the ethics things? Is that one of the, what category does it fall under?
In my recommendation, I don't think it falls in any category. The board may find different, but I did not find that it falls into any ethical violation, one of the 11s.
That's what I'm thinking. It doesn't fall in a category. So we can't find her guilty if it doesn't fall under one of those 11 categories.
The allegation, it doesn't stem from the hearing. I mean, it doesn't stem. So there are several things in that complaint. We probably should print that complaint so y'all can see it, but the issue isn't just what took place with the election board. The issue is what took place in administration. We don't want to call it proceedings, activities pertaining to the removal of Dr. Harris and her statement in rebuttal of whatever complaint was filed against her within the board. So the account of perjury is separate from the actual election board proceeding.
The count of perjury is against Dr. Harris.
Yes, ma'am.
So
Or something she did, in their opinion, the complaints and opinions, in the administration of this or the activities of this particular board, not dealing with her being voted for the election board.
So, and the email that we received said that she said Harris did appear before a grand jury,
She did not. It wasn't part of the alternate process.
but that's still not an ethical violation, though.
I agree with you.
So what would we be voting on if we vote for violation of ethics?
The complainant alleges that they intentionally gave false information because they never went before the grand jury. So they misrepresented themselves in that email.
I understand that, but still, what of the 11 things that we have to vote on, which one of them would it fall under?
It does not, in my opinion.
Yeah.
Would you all like to see the meeting?
I would like to see the meeting. There's underlining issues with that complaint,
But
but it doesn't fall under.
we're trying to conduct an investigation. Are we supposed to be doing the investigation or just looking for probable cause to?
That's a good, fair question, because there are certain things that For this portion, I would say yes, because when we're looking for probable cause, we're looking at what the complainant provided.
Okay.
And the complainant referenced this as part of their complaint as to why it should be looked at into further. So I did watch the meeting because that's what they asked me to look at.
Okay.
Okay, good afternoon. Welcome to the Henry County Board of Elections and Voter Registration Committee special call meeting, 5 p.m. Wednesday, May 28, 2025. I'd like to call the meeting to order. And I would like to ask our county attorney to kind of go over the process and why we're here today, so that the public can understand what we're doing.
Good evening, Madam Chair, Madam Vice Chair, Commissioners, members of the community. We're here tonight to appoint the member at large to the Henry County Board of Elections and Voter Registrations. As you all know, the Henry County Board of Elections and Voter Registrations has 5 members. 2 members are from the Republican Party, 2 members are from the Democratic Party, and then there is 1 at-large position that this board is charged with appointing to the board. Pursuant to Section 4 of the local act that created the Henry County Board of Elections and Voter Registration, the Henry County Board of Commissioners, as the governing authority of Henry County, is to form the committee for the special purpose of appointing this at-large member. And this member must be at least 18 years old, a resident of Henry County, and a registered voter of Henry County.
Okay. Is there any questions from the board as to why we're here today? Okay, all right. So in doing this, I'd like to open up for nomination. I'd like to open it up for nominations.
Chair,
Yes.
I would like to make a motion, and I move to appoint Benita Harris.
Okay, so I have a motion from Vice Chair Robinson of Benita Harris. Are there any other, let me see if it's any other nominations. Hearing none. We got a second. Okay, got a motion and a second. All those that are in favor, raise your hand. Okay, any opposed? Yes, okay, I'm sorry.
Commissioner Robinson, tell us a little bit about her nominee. I don't know who she.
Stephanie, did you receive anything from Ms. Harris?
No, ma'am.
Okay,
I will.
okay, go ahead.
Okay, she has been living in Henry County for over 20 years. She is a registered voter. She is dedicated to the process of ensuring that everyone has a voice. I don't know her really personally, but I do know her from the community. And I do see that she is fair across the board and will serve Henry County well when it comes to our board. And I really feel that she has a heart to serve and she will serve fairly.
She is recently retired from the CDC. So she worked for the federal government and recently retired from the CDC. Any other comments from the board for Ms. Harris? Okay, so we have a motion and a second. Any other questions? Commissioner Wilson?
No.
Okay, all right, so all in favor? Any opposed? And I abstain because I do have a personal relationship with Ms. Harris. And I don't want to take a vote and for it to be misconstrued by the public. So hearing that, there was a unanimous vote from the board with the exception of my extension. And the next step would be to, the county attorney will read the, resolution appointing that, at-large member, into the minutes.
We have a resolution of the Henry County Board of Elections and Voter Registration Committee for the purpose of appointing the at-large member of the Board of Elections and Voter Registrations member. Whereas the Henry County Board of Elections and Voter Registrations consists of 5 board members, 4 of which are appointed by political parties, and 1 of which, the member at large, is appointed by a committee of the Board of Commissioners of Henry County, Georgia, for the purpose of appointing the member at large. And whereas the member at large serves for a term of 2 years, and whereas the current member at large has provided notice to the Board of Commissioners of Henry County that she does not desire to be reappointed to serve as the member at large. Whereas the Board of Commissioners of Henry County, Georgia are the default members of such committee pursuant to Section 4 of the local act creating the Henry County Board of Elections and Voter Registration pursuant to Georgia Law 2006, page 4062. And whereas on May 21st, 2025, notice was provided to the public that the Henry County Board of Elections and Voter Registrations Committee, the committee, was convening a called meeting for the purpose of appointing the member at large to the Henry County Board of Elections and Voter Registration. And whereas the called meeting was held on May 28th, 2025 at 5 p.m. Now therefore be it resolved by the Henry County Board of Elections and Voter Registration Committee as follows. 1. The committee accepted nominations for the member at large for the Henry County Board of Elections and Voter Registration. A motion was made and seconded to appoint Bernita Harris to the Henry County Board of Elections and Voter Registration as the member at large. Said motion was approved by a majority of the members of the committee. This resolution shall be effective immediately upon the adoption and is herewith adopted this 28th day of May, 2025.
Can I get a motion to approve this resolution for this appointment? Got a motion and a second. Is there any questions or discussion? Hearing none, all in favor? Can I vote on the resolution if I abstain from the, or should I abstain from it? Okay, I abstain. So, abstain, you got the majority vote. You got that for the record, Stephanie, just in case somebody want to do an open records request? Okay, thank you. Meeting adjourned.
Yep. Just, same.
I mean, I just have one final question. I mean, I don't see any probable cause there as far as the meeting. And this may not be an appropriate question, but I'm gonna ask it anyway. At any point, anyone, any commissioner could have not voted to appoint Bernita Harris, correct? Anything.
The reasons I've stated to the board, my recommendation for those alleged violations before you is to dismiss for lack of.
Can you remind us of what the actual complaint is
Okay.
against Dr. Harris?
So the complainant put it all in one. And so,
Okay.
this is kind of where it is. First thing that the complainant says is that Ms. Harris committed perjury to the Henry County Board of Ethics by stating that the grand jury appointed her. Although board member Dr. Pike advised that the grand jury did not interview them. Then it said that both of them had a pre-existing relationship. That pre-existing relationship was prior to Ms. Harris being appointed to the Board of Ethics. She represented Chair Harrell in an official capacity and formally organized the business together. And based on that relationship, Ms. Harrell and Ms. Harris violated the code of ethics. And that Ms. Harris committed perjury while serving on the board.
So was this complaint after the meeting? After the board of commissioners voted on this?
Yes.
And the alleged act of perjury references what in particular?
The statement in an email written to the board of ethics. Wow, Ms. Harris.
I just want to say in regards to the allegation of perjury, that meeting was conducted in executive session.
It wasn't the email, however, came prior to,
Yes.
it was shared with the entire board. I just want to make sure we're voting on the right allegations. So we can fully understand her complaint, the complaints and complaint. And fully understand what it is we're voting on before we make this motion to vote. Does anybody have any other questions?
Oh, I'll just make the statement, to me, in my understanding. The email came in, we discussed it. And an issue at that time was the fact that there was a misstatement
Yes, sir.
about appearing before the grand jury. She was dismissed from the board. To me, that makes the perjury moot.
An action was taken to
Right.
reprimand.
I agree.
I do as well. Would anyone like to make a motion to vote on those individual counts or all together? Please make a motion if you're ready to vote.
I make a motion to vote them all together.
I just. I mean, this is that last one, right? Is a stickler because of the fact that there are interests there. She was not present, and I don't think it was required, but that can be an issue.
And they also asked, well, someone asked, did she submitted something to them?
And she said no.
They said no. So nothing was disclosed. She didn't submit it.
But my question would be, if she was not there, why would she have to, how could she disclose? But the chairperson, the person that she had the relationship with.
No, I'm just saying that during the meeting,
Mhm.
right? I don't know who the person was, but she mentioned that, well, she asked, she said, did she, Dr. Harris, did she disclose or share any information about herself? And then the answer was no. So the question is failure to disclose the interest. So if I did not disclose something, I just say, you know what, let me not just say anything at all. Let me not submit anything. Even though I may know this person, I may know that person, I didn't disclose it. I didn't willfully say, I know, what's her name? What's the other lady that nominated her?
Nita Robinson.
Right, she purposefully, right, because she did not send anything in.
But-
I'm thinking, I don't know, I'm just saying,
I guess my question would be,
Basically,
is it a
that she asked.
requirement? Is it a requirement for her to do that?
We would have to look at the application for that.
Yeah,
person.
I don't have to know if that's a requirement.
Yeah.
Because if it's not a requirement, she may not have known. She's getting appointed to something. She was not on something. You don't know all the rules and regulations when you're not there.
Which may warrant an investigation for us to understand all the rules and regulations so that we can
But
make a decision on whether there was a failure to disclose of interest.
I think that, yeah, we probably could look at the application, but I think the person that, if we thinking she failed to disclose, we maybe need to be looking at the member that knew her and did not disclose.
It may be
And vote.
decided.
I mean, I'm just asking.
So
Okay.
basically, we may need to vote for those individual counts.
Before you vote, I want to point out to the board, there is a period of time in which Ms. Harris could not have violated the code because she was not an official. This is this period of time, because at that point, she was off of the Board of Ethics, so she's not subject.
To the
And she
same
had
rules and
not been
regulation.
appointed anywhere, so she was not an official.
I agree.
So there's this gap period as well, and that application process is within that gap period.
So do we know that for a fact? that the application process was prior to the gap period.
Yes,
Do we know when the initial application began, the date of that initial application?
well, we know that to be a fact because we know when they actually voted and passed the resolution to put her on the board. So before then, she wasn't an official or an employee because you have to be voted on. And then by that time, she had already been removed from the Board of Ethics. So we do know that for a fact.
So do we know what the proceedings and procedures are for electing someone to the board?
Yes, so before you,
Mhm.
it's codified what the procedure is. All of the Board of Commissioners have to do is provide a notice to the public, have a meeting and vote.
Okay.
And then
What's the responsibility of the party being,
they don't have to, they only have to be 18.
Yeah.
They don't even have to apply.
That was my question.
It's not-
That's my question.
Yeah,
that's the
Yes.
question.
Yeah, that's the question.
That's the
They have
question.
to meet those three 18.
Greenville County
So-
and voter.
Yes,
So basically, they just have to be appointed, nominated by a
and
commissioner.
they only have to be nominated.
Mhm.
Now, if the board themselves have an internal procedure that they like to see,
Mhm.
then that's different. But per the local ordinance and codes, there doesn't have to be an application.
So another question could be, was she aware that she was going to be nominated? And, like,
I don't think it would matter. Me personally, I don't think it would matter because she hasn't taken a sworn oath. So she hasn't really violated anything because she hasn't been sworn into anything. If someone nominates me after I take my oath or when you bring me in for training, now I have a right to disclose. But prior to that, I don't have to disclose anything until I accept the position.
so
Well-
I'm not necessarily saying that she's at fault for anything. I'm asking these questions because it's coming to me and I want to know. So, my thing is, it seems to me, and this is just my observation, just from looking, the person that nominated her, I don't know who she is, but whoever she is, it just seemed like there's just some more that needs to be asked.
Because when she spoke about, she has the heart of,
Yeah.
the heart of someone you don't know personally.
Right.
But the question also, failure to disclose, once you've been nominated, this Dr. Harris now sits on the board. So in order to sit on the board, we take an oath. When we take an oath, there are certain things we're signing off on. We need to see what that is so that we know that when she's certified and accepted the position, was there then any indication of or reference to disclosure of relationships? That's then that we beg to ask the question, was there a failure to disclose? Because there's one thing to be nominated, but she now sits on the board, so she accepted. And when she accepted, what were the terms of her exception? And what was her oath? And that, yes, ma'am.
That will have to be a different.
I was going to say, wouldn't that be a different complaint? Because now we're going further than the complaint.
That would have to be a different complaint because
It would be,
that
it would be.
What was the complaint in?
It's perjury.
Perjury.
No, it's more than perjury. There are several things that she's complaining about. Perjury is just one part of it.
It was that she didn't disclose that she didn't have that pre-existing personal relationship prior to being nominated to the Board of Ethics.
So the actual complaint written says prior to.
This word for word.
Okay.
This is not
I just want to make sure.
Yes, I took
Okay,
this word
because
for
I don't
word.
want interpretations to be interpreted and we miss any words that were.
And I think you all have a copy of the original
Yeah.
complaint.
It's with
It
Ms.
says,
Harris.
it's in your email, so you'll have to pull up your email.
Was she
And
asked?
I can pull up, well, I can't pull up.
It said
Miss Spanish.
clearly had a personal, pre-existing actual relationship with Ms. Harris. A relationship.
Was she asked that point blank prior to? I mean, that's my question. Is that written? I do not know her. I mean, that's what you're.
But that was Ms.
Different
Robinson.
person.
Ms. Harris acknowledged the relationship.
Right. Two different people.
So
To me,
this complaint said she had one with Ms. Harris. Ms. Harris acknowledged that they had a relationship.
that's the thing.
That's not what this is
I
saying.
can read it. I have the complaint. I can read it word for word.
Okay.
Chair Harrell and Ms. Harris clearly have a pre-existing personal relationship. Ms. Harris has represented Chair Harrell in an official capacity as evidenced by Ms. Harris's own social media. Ms. Harrell and Ms. Harris formally organized a business together. My complaint stems from the removal of Ms. Harris from this board due to the appearance of impropriety. Ms. Harris submitted an email to this board stating she appeared before a grand jury twice in that email. Dr. Erica Pike was appointed the same day and in the same manner as Ms. Harris. Dr. Pike stated they candidates did not interview before a grand jury. I have requested the grand jury appointment form via ORR to Henry County. If Ms. Harris did appear before a grand jury, that document should exist exactly the way.
I know what that word is.
If Ms. Harris did not appear before a grand jury, then she lied to this board and that constitutes perjury. That is the totality of the complaint.
Okay, so if we're looking at the complaint itself as written per the allegations off of Senate Bill 22, as you laid it out on the other slide.
This one?
Yeah.
Oh, sorry.
That's the one. Based on the discussions, there was no, well, this is where it's a little confusing because the disclosure is not based off of the appointment. The disclosure is based off the relationship as it pertains to the appointment to the Board of Ethics.
Correct.
So, in that regards, I think that matter has been resolved. And with that said, I will make a motion to adopt your recommendation.
Recommendation of what?
For dismissal.
Of which charge?
All of it.
Give me 1 second.
That's a question. So once the person is appointed, that they're friends with, or have a relationship with, is it that it's going to be some sort of violation with their ethics working together, being that they're friends or they know each other, or that's not a thing?
I can't say it would be a violation because it's so circumstantial based on what could come. Because the problem with having personal relationship with people is it can develop into violations.
Okay.
Impartiality in performing official duties. Well, now we know there is a personal relationship. So if the board later got a complaint and the violation is in part our failure to show impartiality, you're going to look, well, was this person not impartial because of that personal relationship? So it's gonna become very circumstantial. But that doesn't mean it's prohibited.
Okay.
I just got a question. So basically, the fact that she was removed simply because of her personal relationship.
From the Board of Ethics,
Board of Ethics.
that's really a board.
Or she failed to disclose it?
All discussions pertain held in executive session, so it won't be repeated. What is our advisory board? The board of claim fails to meet jurisdiction. Okay. All right, let's do it. Mr. Valmay has made a motion to dismiss all complaints or allegations, as a whole for lack of probable cause. Is there a second to that motion?
As it pertains to the complaint,
As it pertains to the complaint written by the complainant against Dr. Benita Harris.
I'll second.
All in favor? Then on to item E. The presentation of the ethics officer of probable cause hearing on case 2025 EB5, John Doe versus Scott Morris and Roderick Whitaker.
Thank you, Chair. In regards to 2025 EB5, we do have personal jurisdiction. Mr. Scott Moore is the Henry County Department of Transportation Director. Mr. Roger Whitaker also works in that same department as a crew lead. The allegations that are made in this complaint is a misuse of position, conflict with official duties, and failure to disclose interests. The complainant alleges the following for the board's consideration. First, the complainant alleges that inappropriate disciplinary action was taken against the complainant for the complainant's inability to work during inclement weather. This is a department where if there's a storm, a tornado, or anything, they have to work overtime because they have to make sure that the streets are clear and clean during the weekend in question. That is the weekend in which there was really, really bad inclement weather. And the individual was asked to work overtime. The complainant alleges that the crew lead advised the complainant would be fired and removed from the crew lead's team. The complainant alleges that the counseling record that was provided to that individual does not accurately depict action. And that counseling record is a counseling record that was given by Henry County HR. Ultimately, what happened is that the complainant informed the crew lead that the complainant had a pre-planned trip and was unavailable to work that week. The policy in that department is that everybody has to be available unless there's some circumstantial situation that causes you to be unavailable. And at that point, your crew leader, the director, can kind of make the determination whether or not you're excused. This individual was excused for the weekend. However, this individual was advised that they had to provide proof of the trip when they returned that Monday. The individual returned on Monday and did not provide proof of the trip. When questioned why proof was not provided, the individuals stated that they flew on a private jet. That is their friends, and they did not have to provide such information. When the passenger manifest was asked, said, hey, well, it's a private jet, so at least give us the passenger manifest to substantiate the fact that you had this pre-planned trip with your wife this weekend. The individual refused. That was on the counseling form that was provided by HR as a disciplinary measure because that individual had not provided that information. In addition to that, the individual's counseling record reflected that the individual was removed and put on another crew because of the negativity that the individual was causing within that same crew. The complainant disputes that in their complaint and indicates that that they were removed because of this allegation of attempts to get fired. When looking at the preliminary investigation and what I had before me, I did notice that it was a crew of 4 and 2 people got removed, not just 1. And they reorganized several different groups. The last thing that the complainant indicated was that the complainant was told that they were not working on the clock as they should and abandoned the crew and left. The complainant indicated that they were taking care of county vehicles by way of maintenance. That county vehicles have to be maintained by way or not vehicles, machinery by pressure washing it. That the machinery had gotten to the point where it was so bad, the complainant indicated that they paid out of pocket themselves and had a different company, a random company come clean it. And that complainant was, I guess for lack of a better word, supervising the cleaning of that machinery. When I looked into the protocol and policies as to county machinery and being cleaned, it is against county policy to just for an employee to randomly contract with a vendor to clean county machinery. And so that was part of the disciplinary counseling forum. The complainant is still employed with Henry County, however, was counseled for those incidents that ultimately they also complained about. The complainant also indicated various labor violations that include bullying and what appears to be workplace harassment, even though they didn't say workplace harassment. What I reviewed was the counseling record forms that was provided by the complainant. I also reviewed the employment posting of job duties and descriptions so I can get an understanding of kind of what the expectations are. This one, I also, I spoke to the complainant for the purposes of just asking, as I customarily do, is there anything else you would want the board to know? And in doing that, I was not attempting to gather more formal investigation, but the complainant did admit to me that they did not provide that record from the trip. And that it was the complainant's opinion that their personal time is their personal time and it's not the county's business what was going on. However, the policy is you could be excused, and the complainant was excused, just had to provide proof that wasn't provided. After reviewing the information that was provided, after cross-referencing with all of the allegations that were made, my recommendation is to dismiss for lack of a probable cause. When I looked at whether or not there was a misuse of position, I did not see any misuse of position garnering anybody extra privileges. Now, the complainant did make some statements that certain people did not have to turn in, I guess, or provide proof of why they were not available over the weekend. However, when speaking even to the complainant, before the complainant left, the complainant knew that was gonna be a requirement or that was the reason they were being excused was because of this pre-planned trip. And the complainant knew of the requirement that was going to be required of them to come back on Monday. Conflict with official duties, this just did not fit that whatsoever, as well as failure to disclose any interest. Any questions regarding?
I think you answered most of my questions. The requirement for him to provide the information, is that a written policy or just by individual or by situation?
I do not believe it's written. I can't confirm because I didn't look up the written policy, but I do know it's a policy because I spoke with the director of transportation. And I was informed that that is, whether written or unwritten, it is a policy that they employ whenever there is inclement weather, whether it's nighttime or whether it's weekend, where they're supposed to be off. It's a, hey, who has something where you are unavailable? And if you are unavailable, tell us what it is and we will let you know whether or not. Yes.
I have 2 questions. In reviewing the counseling for this individual, were there any other counseling prior to this event that was either positive or negative?
I don't know because I only reviewed, the counseling form was submitted to us by the complainant. So I didn't go look into their HR file.
And my other question is, was there a complaint lodged by that individual with HR or any other entity outside of the ethics board?
And I wouldn't know because that goes into more of a formal investigation when we start subpoenaing the HR file. And we don't subpoena typically at probable cause.
I have a question. The non-written rule that has been verbalized to the employees, is there proof that that verbal rule was not applied to other employees when in fact they had the same absences? Were they required to submit and did they submit? And then what was the reprimand for them not submitting if that indeed happened?
I would not know if that happened at this stage because that would require a formal investigation. I would have to actually interview the witnesses to see who else may have made requests and what was the process of that request. I just know generally what the policy is.
Can you define the misuse?
Sure. The misuse of position is when a person appears on their own behalf or represent on the personal behalf of any person, any court, legislative, administrative, or quasi-judicial board, agency, commission, or committee of this state, or any county or municipality concerning any contract or transaction which is or may be the subject of an official act of Henry County, or otherwise use or attempt to use his official position to secure unwarranted privileges or exemptions for himself.
Okay. So, in considering the questions that the board has asked and the recommendation of, or the complainant's allocation of ethics violations, the misuse of position, conflict of official duties, failure to disclose interest, is it possible that the situation is more suitable for a different ethics violation investigation? And is it suitable in this case to maybe ask the complainant to revisit their complaint and resubmit before we vote to make it dismissal? Because technically the complainant has a right to amend if in fact they've appropriated or they've mislabeled their complaint. Because it sounds like what they're really complaining about is impartiality.
I would agree that impartiality would be more fitting.
Is that checked on their complaint?
No, it's not. The only thing and ironically, it was checked, but they marked it off.
Oh, okay. I was gonna say, yeah.
Yeah, that's not me. It was checked, but they marked it off. I will say it appears that if there would be further investigation, it would probably be under that impartiality and they would not have to amend their complaint. The board can find probable cause on other. That makes sense?
Yes, ma'am.
Okay.
Well,
and I would also say that I believe if there will be proper cause on impartiality, I do not believe that it would be so in regards to the harassment and bullying. I believe those are HR and more labor law employment issues. And I would recommend, I actually asked the complainant, the client speak with an employment attorney because those things better suited for that avenue.
okay. That kind of like makes my question a moot point, but I'm still gonna ask the question. So with providing the documentation, the travel log or the flight plan for his trip, he received counseling, correct? For that?
Oh, they call it a counseling form or a counseling record form, and that was not the only thing. It was a written form for a lack of accountability improper attitude, insubordination, and clocking in and out early, and improper language. No, not, yeah, improper language, and it just specifically talked about the inclement weather with, the failure to report because of her planned trip and to provide it, and then it also talked about the negativity of being removed. And then it lastly talked about the pressure wash of the machinery.
Did he acknowledge did he acknowledge the accounts? Meaning either he signed on it or he said he received it?
I don't see a signature on this form, but on the form, it has handwriting that says provided and signed June 4th, 2025.
Okay.
But I see a supervisor's signature, but I don't see an employee signature.
And the final part of that is there a spot for a rebuttal, and was a rebuttal provided?
No spot for rebuttal. It says that the council issued a written warning, advised that continued behavior will lead to more severe consequences. When it comes to taking care of the equipment, the individual stated that, reason that the individual did not inform the crew leader that they were leaving it to pressure wash on the county machinery was that because that individual was taking care of equipment.
And just to revisit what you were saying earlier in partiality, the other two individuals that were removed, was there a reason given for those individuals being removed?
Not in the information that was provided me, but the complainant did not advise that those two other individuals or that one other individual was removed. Actually, I take that back. The complainant did advise that. The complainant did inform me that there was one other individual who was removed and gave me that person's information.
Was it because of disciplinary actions or?
They did not say why. The complainant did not say why the other person was moved, only the reason that the complainant felt they was removed.
So they provided you their information so that you could call them and get more information, is that what it?
So they provided me that individual's information because I asked. So when they told me someone else had been removed, I asked, who is that other person? Just in case I may have needed that information if it got to a formal investigation.
As it relates to impartiality, the counseling form that was filled out for that particular employee, the complainant, was there a reprimand or information pertaining to the absence and the lack of providing an excuse for that absence?
Yes. Well, there wasn't an explanation from the complainant. The complainant told me the explanation.
No. I mean, on the counseling form, when they reprimanded this particular employee in the counseling form from their supervisor or director, did that counseling form include the reprimand for not showing proof of why they were not present or they didn't come?
That's the council.
So in other words, were they reprimanded for not providing proof of travel?
They were counsel and issued a written warning.
So they were issued a written warning for not providing proof of travel.
They lumped it all together.
Okay.
So that was.
That's the counseling.
Yeah, that's the council.
Okay, that's what I want to know.
And then I will say as well in the complaint that the complaint actually indicates that 4 of them was removed and they were told that they were switching teams due to it needed to be the changes that needed to be made. So that's what the complainant indicated, that they were told changes needed to be made into with the crew. The complaint says 4, but I was informed that 2 were moved.
Because impartiality doesn't just involve those individuals or employees that were moved from one group to the other. It involves every employee. And so if every employee within the department has a standard of practice of when you're not here, you have to show proof. If it's not a written rule, it's an oral understood rule for the entire department, then it's the rule for the entire department. Whether they were reprimanded or not is the question of whether there was then impartiality shown for not reprimanding someone else for not providing the same evidence that is required for this particular individual. That's where my question of impartiality would come from, not just because someone was removed from a group and put in another group. One doesn't have anything to do with the other.
I have questions. The counseling, prior to the counseling, was there an email requesting documentation for the absent
There was a conversation.
conversation? There was no email. No formal request. I'm gonna say it like that.
I did not ask that. The complainant themselves told me that before they left, they were told, when you come back, you have to provide this on Monday. I inquired with the complainant, why didn't you provide it? And then that's when the complainant advised me, my personal time is my personal time. I shouldn't have to.
Whether written or oral is still considered formal, correct? If it is
Yes,
that,
because that was the process for everybody. Now, the complainant did say that, several people missed the weekend and that they felt as if they were the only one required to provide a boarding pass or the itinerary. But because it appears that there, and I don't know for sure, but it appears there's no formal written policy. It's really at the discretion of supervisors, and I don't know if they do it by seniority or what, but it appears that, the issue really came with the refusal of just providing the documentation because that individual was excused to go. Problem did not arise until they came back and did not provide that documentation. So the private jet also didn't go.
I'm sorry, I forgot your name. Alicia, I'm in agreement with what you're saying, impartiality. Because in his complaint, he alleges that someone else made some inappropriate comments. So we don't know if they got written up, and what he's saying about the other people taking off, we don't know if they got written up. So we would have to do, I think we would need further information to determine if it was impartial or not.
all right, so, why don't we, someone wants to make a motion to vote on the individual counts or the whole of the listed counts for probable cause hearing. We'll do them individually if everyone's okay with that.
And Chair, before you all vote, I will point out too, this is two people in one complaint. So the first one is Mr. Morris, who is the director of DOT. And we had not gotten to the same one, but it is similar to the last one, same allegations, which is the crew leader.
Who filled out the forms and signed the forms?
The counseling form?
Yes, ma'am.
Morris.
Forms.
Let me ask just a question for it. So are we saying that if all the other individuals receive counseling similar or a counseling, then we're okay versus this one individual receiving the counseling? That's what I'm hearing?
If it's impartiality, we would have to know if we're saying it was, he had it checked and he unchecked it. If he's saying it's impartial or we amended it to impartiality, everybody should be receiving counsel uniformly.
That's what I'm saying.
Shouldn't be selected in counseling.
And that's what I'm trying to figure out. Are we saying, is that what we're saying?
Yeah, that's what I'm saying.
If there's a standard of procedure, then it's a standard.
Okay.
And if it's a standard, the standard for the department is what I will.
I just want to make sure I understand.
And to make sure I understand, it's not everybody didn't take a trip. Like some people had maybe like family engagements. I think there is one individual that was brought to my attention that apparently they're really involved in church. So usually they're excused so they can attend their religious ceremonies. If I'm hearing the board correctly, you're saying whatever the standard is, does everybody have to show proof?
I guess that was my question. That was gonna be my question. Was it required for the others to provide some type of documentation?
I don't know, but it appears that if the board determines that there is probable cause on the impartiality, that's what I wanted clarity on. So when I'm doing my formal investigation, I know what I'm looking for.
So in that case, to cover that, you would have to look at the other counseling to see what they were counseled on. And does it, because we know, well, they were removed. The other individual was removed as well.
The removal is a separate instance.
Yeah, one doesn't have anything to do with the other.
The removal came from,
A realignment, not disciplinary.
it depends on whose story is being told. According to the complainant, the removal was due to the crew leader saying, I'm gonna get you fired, basically. And they also said that there was 4 of them that they were doing some restructuring. Now, when I spoke to the director of DOT, it was indicated that 2 were removed because there was doing restructuring. So those parts match between the complainant and DOT. The complainant just also feels like, in addition, that what he was told is not the truth. That it was all a scheme and working up to get that individual fired.
But who was removed or who was fired?
Nobody.
And from the counseling is rehabilitating counseling, from what I'm saying. It's not a threat of being fired. It's corrective counseling, from the way I look at it.
Correct, that could lead to more serious consequences if behavior did not change.
Exactly.
Yes. And so the thing about the counseling form too is it's hard to see if everybody got counseled on what to provide proof of, because this counseling form was for this individual for multiple reasons. It was for 3 different incidents, including the individual choosing to personally pay for this private company to come in and clean machinery. Instead of using the proper protocol, from my understanding, is that you use, go through your crew leader, and the county has vendors that they contract with, or the county has their own pressure washing machine that you can use, the employees can use, but you can't just call a friend and say, hey, can you come clean my machine and I'll pay you.
Because the property doesn't belong to the, it belongs to the county.
Liability, but
Yeah.
The county.
So the counseling forms stem from all of those things in the aggregate instead of just one thing of not turning in proof of paper.
Here's my thing with the whole thing. He was under a crew leader that was threatening to fire him. He was moved to another. He's still employed. He broke policy in the fact that he was using an outside company. And he was asked to provide proof, which he could not. To me, he's admitted some of the faults that he knew were already in place. To me, so I think I look at it as for dismissal.
The issue with that, for me, is for impartiality is if we look at the individual, so there are several items listed in the counseling form. And where some items in the counseling form obviously is warranted. We just need to confirm that the item regarding travel is also warranted based on procedures for the entire department. What is the standard? And if everyone is held to the same standard. Because the other 2, we know that even just by county rules, that he violated by having someone touch that equipment. But that's even beyond his department. But for that, in particular matter, is what my concern with impartiality, or just clarity, because it may find itself to be fine, but that's just an investigation for clarity.
I agree with you, but I will just.
You don't have to.
No, I do agree with you. I will just say this though. It seems that they allowed him to go on the trip. And then when he returned, they requested the proof.
The definition of allowing an adult to make a decision on their own doesn't really exist. All they didn't do was fire him because he took the trip, because he as an adult made the decision to take the trip. It wasn't I'm going to allow you. He informed them he wasn't showing up. They didn't say, hey, don't come. He informed them, hey, I'm not coming. They're like, okay, when you come back, provide proof of this particular trip. I don't have tickets, we'll provide the manifest for that particular flight plan. I don't have, for whatever the excuses are, we just got to make sure their punishment is valid for this particular person and make it valid for others.
I do.
But he made a choice, whether his choice was a great choice or not, they didn't make the choice for him to go on that trip. They didn't, it wasn't because if you're at home and you get ready and you walk out the door, they're not gonna stand in front of your door and say you can or can't go. That's not an allowance. That's you making a decision. He made a decision.
But that creates another problem.
What is
So
that?
this is a problem for the county, for the supervisor, let's just put it this way. Because there are rules, and if we want to look to make sure that the rules are fair across the board for everyone, that's fair. But there are rules, and you cannot just say, I'm going to do this as an employee. You just can't do that.
Right, but once he made the decision, so if you get sick today and you call your employee and you don't show up for work, you can't actually decide you're not showing up for work. What they do afterwards is based on procedures and rules of that department.
And they'll ask for taxes. No,
It's fine. We're not discussing whether or not it was okay to ask, because if there's a rule in place, oral or written, it is what it is. He got to follow the rule. We just got to make sure everyone else is being held to the same standard. That's really the only question.
That's my question and everyone else, because I think someone else was out too. But they required to provide anything, because if I tell you I got a family event, you say you got a trip, and you ask for airline ticket, why aren't you asking me for something?
An itinerary for that event and proof that I attended.
Or something, or even a church service? Where's the program? Why one person has to present and not another one is a question. It should be the same across the board. And my other concern would be, he alleges that this other guy made inappropriate language, but I don't know if he got written up or not, but in his complaint, he said he used inappropriate language, but he got written up for inappropriate language.
The other guy is the second person of this complaint. He is the crew leader.
Okay, so we'll deal with Mr. Morris first, and then we'll move on to decide whether there's possible cause or okay.
Let me just say one thing to what you just said. It's at the discretion of the team leader for disciplinary. So it's a fine line whether or not that team leader made a decision, and we cannot really, unless we find, there are issues there. But to be honest with you, it's the team leader's discretion as far as how they are leading that particular team. And you may find where there are people that, you're okay. This other person has a disciplinary problem, and you have to be a little tougher with this person.
But normally, most agencies, especially government agencies, they have policies. We don't just make up policies. They have written policies in place. So I'm sure there's something that may not be as defined as we want it to be, but there's a policy that's outlining something in relation to this.
It should be.
Here's where we are. We're not in the hearing state, so we're not making a decision of right or wrong. So when we say, hey, there's a definitive this or that, we don't know. That's the point of it all. We want to know more so that we can make a determination if there's definitive definition or if there's leeway and discretion. We don't know the answers to that. And that is the entire point. So having an opinion about, well, if he has discretion, he can just, we don't know. Until we get the policies and rules of that department, we don't know if he has discretion. Because if I say something, because I'm a supervisor, but you really don't know the rules in which I have to perform my duties within, then I could tell you anything, and you just gotta believe, unless you go to human resources yourself and understand what, the policies and procedures are for me to even hold my position and how I function in this position. Sometimes you can say what you want but we just want to know. We're just literally, we want more discovery. That's it. We just
I agree. He should have got written up. There's multiple written up for, but
yeah, we're not saying that.
Yeah. It's still the same for everybody else.
That's it. Yeah, we didn't say he didn't deserve it. We just said make it fair and right up everybody if that's the case. We will make a motion for. Would anyone like to make a motion for 2025 EB5 John Doe versus Mr. Scott Morris and the misuse of position? Yes, ma'am.
So are we are we voting for getting more information through an investigation, like further investigation? Is that what it is?
My understanding, and y'all please correct me if I'm wrong, is you're voting to adopt the ethics officer recommendation. However, you're voting to find probable cause on impartiality for failure to the impartiality violation. So you're moving forward on other findings that are not findings of the ethics officer.
So I
Is that what you all are doing?
That's what I'm recommending.
Yeah, so it sounds like.
There are gonna be two motions.
Yes.
So there'll be two, the first motion will be to find probable cause for each individual item listed above, and then the second motion will be to find probable cause to amend the complaint and add impartiality and to move forward in probable cause. Yes, Mr.
I'll make a motion on what we have before us. The three items, I will motion to dismiss for lack of probable cause.
Is there a second?
I'll second.
All in favor? That's unanimous. Would anybody like to make a motion to amend the complaint and add impartiality, and probable cause for partiality?
I'll make the motion to amend the complaint to add impartiality.
Second.
All in favor? Everyone except for Mr. Craig.
The next one includes the same facts, same circumstances, different individual. This individual includes the crew leader or is the crew leader, Mr. Roderick Whitaker. My recommendation for the same reasons mentioned earlier was to dismiss for probable cause based on the allegations that was stated within the complaint.
What is Mr. Whitaker's role in the complaint?
Mr. Whitaker is the individual that the complainant indicates said that he was gonna get the complainant fired and removed off of the team, and that individual made improper language. The complainant never said which individual required paperwork for that individual to be excused. So we don't know if that was Mr. Morris or Mr. Whitaker.
So in the complaint, as it relates to Mr. Whitaker, the complainant mentioned that Mr. Whitaker verbally said, I'm gonna do everything. So what is, I don't want to misrepresent.
Quote it verbatim. He was going to get the complainant fired and didn't want the complainant on his team. That the complainant felt bullied and targeted as no one had been written up because of the comments being made to that individual about being fired. And let me correct myself. It was not Mr. Whitaker who made inappropriate comments. It was Mr. Morris that indicated everyone needed to let their nuts hang. So that was not Mr. Whitaker, that was Mr. Norris.
Okay, so who's the supervisor? Who's the direct supervisor?
Mr. Whitaker.
Mr. Whitaker.
And Mr. Morris is the director.
Director, got it, okay. All right, when those statements were made, were there any witnesses or any other persons there to collaborate? What was
There's
said?
a witness list that was provided, but at this stage, I don't call the witness a probable cause. But the individual did provide 1, 2, 3, 4, 5, 6, 7 witnesses.
A witness the statement being made.
And witnesses in general regarding the complaint.
Is there anything else as it relates to Mr. Whitaker in the complaint?
Not with him named directly. Some of the things are general things, but don't say whether it was Mr. Whitaker or Mr. Morris. It just states that I was told this or I was removed because of this reason, but it doesn't say who actually did the removal.
So Mr. Wicker saying that he didn't want him on his detail anymore, his
crew.
Did Mr. Whitaker then take action?
I don't know, because what we do know is people were moved. We don't know time frame. We don't know exact reason they were moved, but we do know that people were moved. And I don't know if he was on his team and then moved or moved later. At this stage, we don't know.
And do we know what prompted Mr. Whitaker to make the statement, I don't want you on my team or crew anymore?
According to the complainant felt like that individual was being targeted.
So there was no prior mention of conversations, words shared, and interactions that prompted him to just say that out loud? Like, there's nothing leading into the why he said that?
No.
He just made a statement. He didn't give any information leading up to it. He said it to him.
And I'm sorry.
What'd you say? He just made a statement saying, that he had said that, but he didn't do that to him.
Mr. Whitaker is not on any of the forms for reprimand.
All right, only Ms. Whitmore was the director.
Okay, so you're saying the director is the one that did the counseling?
Yes. We said that earlier, but Mr. Morris.
Mr. Morris is the direct supervisor.
No, Mr.
Okay.
Morris is director. Mr. Whitaker is the crew leader.
The crew leader.
So when the crews were reassigned, who did the reassignment?
But no, at this stage. And I don't want the board to think that, I can't answer the questions, but at the preliminary investigation, we typically go just about on the face of the complaint and the evidence that's provided, because we're looking at the jurisdiction and if it's just enough to kind of give you probable cause. One of the reasons I have a little more information than I typically probably would have is because when I called the complainant, as I customarily do, to see was there anything to supplement the complaint with, they spilled everything, or this complainant spilled everything. So I had a little more background information.
Do you know whether or not there's normal procedures for the director to counsel someone outside of their direct supervision? Is that normal?
I've seen that before in other investigations where a person may have a direct supervisor, but then the crew leader or the cluster lead, not the crew leader, or the director will actually do the HR discipline portion of it.
What does that even fall under? The complaint against Mr. Whitaker? Is there any ethics?
I think because so much is unknown, it is my opinion, if you find probable cause on Mr. Morris for impartiality, you almost have to do it for Mr. Whitaker too, because you don't know who did what. Both of them were pawns in the scheme, but you don't know who gave direction. You don't know who recommended the removal. You just know both of them had a part in something. And if it comes during the formal investigation that Mr. Whitaker did not do any of the recommendations, he didn't ask to be removed, then the board just dismisses it on Mr. Whitaker. Vice versa for Mr. Morris, but it seems like both of them are so closely tied in the situation. I don't see how the board can find probable cause on one and not the other.
I think I would like to ask that. I could see how we can, because Mr. Whitaker is a direct supervisor. Mr. Morris is over Mr. Whitaker. So just because I make a recommendation, Mr. Morris didn't have to do it. He could have stopped all of that. And if this problem employee was on my team, I would want him removed. That would be something I would request. We're not getting along. I'm another team.
And that's fair. But here's the thing, though. If Mr. Whitaker has no power to remove or to transfer or remove, he can only make a recommendation to Mr. Morris.
Yeah.
Mr. Morris then has all the power, which is why Mr. Morris is the only one making the recommendations and signing the counseling forms and issuing the warning of there could be more severe punishment. It sounds to me like Mr. Whitaker, and correct me if I'm wrong, but it sounds like a crew leader is just basically a safety patrol. I'm just out here making sure y'all doing the job right.
You're a lead.
Yeah, like I'm the project lead. And I'm just making sure the project is being facilitated correctly. But the person with the real power is Mr. Morris.
Yeah.
That's how it sounds.
If that's an assumption we'll have to make because we don't know. And I can't advise you on that. I don't know how much authority the crew leader has. I guess by title, I can assume that a crew leader would not have the authority to remove someone from their team, but I don't know that with certainty. I also don't know if who gave the individual or who said you are excused from this weekend, but you gotta bring me proof. That could have been Mr. Whitaker as the crew leader who has the authority to make that decision to dismiss crews for the weekend.
But even if Mr. Whitaker requested, Mr. Morris co-signed it. Mr. Morris is the one that issued the counseling reprimand for that particular action. So even if Mr. Whitaker asked for something and the guy blew past him and said, oh, I'm not giving it to you. Mr. Morris then followed with, hey, this is procedural and you must do X, Y, and Z. It sounds like he wasn't disciplined by Mr. Whitaker. He was actually disciplined by Mr. Morris based on the counseling form filled out and signed by, because you said the supervisor's signature was Mr. Morris. So that means his supervisor, but tell me, you said you have the form, you say, is it?
No, it was Mr. Morris, but it could be both showing impartiality. Because if I'm the crew leader, but I only require one person to turn in proof of a trip, then I'm being impartial to that one person.
Not necessarily, because it's not your requirement, it's your boss's requirement.
Exactly.
You're following procedure. You're asking for something that has been told that you have to ask for. When in fact he didn't supply it, the person above is the one that reprimanded. Mr. Whitaker didn't reprimand. He may have, basically, if you give your assistant permission to make a call and request information on your behalf, your assistant requested the information. But when in fact that information was not provided, the boss actually came down and said, okay, I need this now or else. And that or else came from the actual supervisor.
So
It just sounds like he was an intermediary issuing for the liaison, basically the conduit. I'm just giving you information provided to me, but this recommendation or this rule of procedure is required by Mr. Morris.
But the question becomes then, how much does Mr. Morris know? So does Mr. Morris know that Mr. Whitaker is only requiring that for the complainant and not everybody else? Because the complainant, Mr. Whitaker, could show favoritism and only saying, I need it from you. And Mr. Morris assumed that Mr. Whitaker is applying it across the board, but Mr. Whitaker only comes and complain about one individual. So to me, they're still so close, so.
The issue is, once the complainant has brought it to Mr. Morris's attention, that I believe this is happening only to me. Mr. Morris is the only one seems to be issuing these well, let me back it up. I can't say he's the only one. But it seems as if Mr. Morris is saying, hey, there's a standard in this department. And if in fact the complainant said, hey, I don't think this standard is being applied evenly, it still falls on Mr. Morris to make sure that it is.
But I don't know if Mr. Morris, I can't say Mr. Morris got that complaint from the complainant, because this complainant is anonymous.
No. What I'm saying is Mr. Morris issued this counseling form. So and then some point he had contact with the complainant. And at that point, the complainant could have voiced their concerns with their supervisor. So that means two things happen. The team or project lead, crew leader, voiced maybe displeasure, but then also once the reprimand was brought down or the counseling session and conversation was had, the complainant also expressed their disapproval of their crew leader. So both did the same thing, and the one with the power addressed it.
I guess the problem
Two
that I
people
would have,
complained, and he addressed it in the way that he thought it was appropriate.
I think the problem I would have in recommending or not recommending probable cause for Mr. Whitaker on impartiality is that calls for a lot of assumptions that I don't know without.
It's
talking
not
to the
assume
complainant.
if the evidence provided in the complaint leans heavily towards one person than the other.
Well, you indicated that the complainant in a conversation during the counseling probably brought it to Mr. Moore's attention about his dissatisfaction.
That's an assumption.
Right. Which
So
is what
we're
I'm saying.
making, but here's the thing though, we're making an assumption about words spoken from Mr. Whitaker to Mr. Morris that we can't assume. Mr. Morris could have witnessed his own, he could have required something that was not submitted. And he could have gone back to Mr. Whitaker and said, hey, where is the documentation or the proof that is required? We don't know that Mr. Whitaker initiated those issues that caused, well, we know who initiated the issues that caused a reprimand, but we don't know that Mr. Whitaker, it doesn't, in the complaint, it doesn't really show or say where Mr. Whitaker played a role, except for the words of, I don't want you on my crew. And it sounds like the complainant set up some choice words themselves based on the recommendation in counseling about maybe some misuse of words or
The
some words.
complainant denied it. The complainant said that he doesn't use, he's never made those comments or improper language and that it was made by Mr. Morris. But as my recommendation to the board would be if we all were going to find impartiality on Mr. Morris, is to also find it from Mr. Whitaker. Because I just can't see based on the complaint you have and how he doesn't delineate who is doing what. And I don't know who is doing what because I haven't investigated. Both need to be investigated, at least that on a probable cause where the standard is so low. Both need to be looked into to see whether or not it will meet the next standard of a preponderance of evidence.
And doing,
See it.
and doing that, I would like to have a better understanding of the authority that Mr. Whitaker has. And has he ever counseled anyone? Because if he has, then it becomes a problem because there's a chain where he is the first level supervisor and there's a second level. And if you're not going through that established chain, that becomes a problem as well. Now, if he hasn't counseled anyone and Mr. Morris is the one that's always counseling, then that goes back to his authority. Maybe he's just a lead and he's just in charge just to get things accomplished, but doesn't have disciplinary actions as far as his role. So I would like to see the definition of his role. Has he, in that definition, is he authorized to counsel anyone and has he counseled anyone?
Mr. Whitaker could have abstained from counseling because he felt he was a part of this complainant's complaint to this department. So he allowed the superior supervisor to then oversee the issue instead of himself. I just don't see what Mr. Whitaker, I don't see it.
But if he counseled before and you're saying
I'm not saying anything.
The complaint involves him, so I can see himself taking
Removing himself from the
that would be, you would be saying that he knew this complaint was going to be lodged. That's not.
No, because here's the thing, if I have an issue with an employee and I go and talk to my supervisor and say, hey, I got this issue with this employee. That employee then walks into that same office and say, hey, I got this issue with my supervisor. You called me in here to tell me that my, crew leader has a problem with me, but I got a problem with my crew leader. So now we both just discussed with the same supervisor our issues with working with each other. Then that supervisor, based on their investigation, made a recommendation. That's what it seemed took place based on the written complaint.
I agree. But what I'm saying is if he has authority to counsel and he did not, then I have an issue with that.
Well, I wouldn't have an issue with that because if I was a supervisor and someone made a complaint against me, you wouldn't expect me to investigate it because I'm not going to be partial.
No, that's not what I'm.
That to me made him.
That's not what I'm
To me
saying.
was him being.
That's not what I'm saying.
Control and saying, hey, be seen as me being impartial if I were to.
No, that's not what
Let me
I'm saying.
remove myself from
Let me clarify. What I'm saying is all of the issues, he should have been the person counseling. That's what I'm saying.
The other issues?
Yes.
No, you can't say he should have been.
Well, I'm saying if he had the authority, that's what I'm saying. That's
You
what I'm
can't say he should do anything.
If he had
until
the
understand
authority.
rules.
If he had the authority, it should be the first level supervisor. That's a count.
And if if he's considered,
Of them and left the one that he's making about.
Yeah.
Then, okay.
but it goes back to authority because it just depends on what, his role requires of him.
Exactly.
So I would agree with, Attorney Bullard. Because we do not know for sure. And I feel like we are making assumptions or could be making assumptions that this could be what's happening or this could be if this, that. But I feel like further investigation needs to happen under the explanation that you gave. Because if it applies to one, then I think it should apply to the other. Because we really don't know what exactly happened, who said what, for sure.
And it goes back to Samuel's point about knowing the true authority that the crew leader has, whether he's a supervisor or is a crew leader, just a team member who's the contact person on the scene. It may be just that simple.
So as it relates to case 2025 EB5, John Doe versus Mr. Roderick Whitaker, would anyone like to make a motion?
Motion that the charges as listed be dismissed for lack of cause.
So Mrs. Easter recommends that the misuse of position, conflict with official duties, and failure to disclose interest be dismissed for lack of probable cause. Is there a second?
I'll second.
All in favor? It's unanimous. Is there a second motion for case 2025 EB5, John Doe versus Roderick Whitaker?
I'll make the motion to look at the case through the lens of impartiality.
Is there a second?
Second.
All in favor? Those in favor are Mr. Kelly, Mr. Lee, and Dr. Valme. Dr. Pike, technically your vote doesn't count as of right now because of quorum. Dr. Valme, Mr. Lee, and Mr. Kelly. So I think we're split down the middle here. We don't have a majority vote for that one. I guess that's where Dr. Pike comes in. You just broke the tie. I think that's how it works. Am I correct? Yeah. So there is,
I'm sorry, what's the vote?
you, Mr. Valme, Mr. Lee, and Mr. Kelly, and Dr. Pike.
You didn't vote?
Yeah, I didn't know.
Oh, okay.
So Dr. Pike. Because there was a tie, Dr. Pike broke that tie. Right?
Oh, that's for the last motion. That's for the last.
That was for the motion that Mr. Lee made a motion to add the count of impartiality. Yes, ma'am.
So, just to verify, the only ones that opposed were Chair and Mr. Craig
And Mrs. Easter.
and Ms. Easter.
Miss Easter.
But then Ms. Pike,
Dr. Pike broke the tie.
you agreed with that. You agreed to go towards impartiality? Yes.
For cause for impartiality. All right, moving on to item F. The ethic officers will present case for 2025 EB6 Ryan Morrison versus Sherry Matthews and Kevin Johnson.
Thank you, Chair. In regards to this matter, we do have personal jurisdiction. Sherry Hobson Matthews is the Henry County's county manager. Kevin Johnson is Henry County's deputy county manager. The allegations before the board is failure to show impartiality in performing official duties, misuse of position, incompatible interests, engaging in activity prohibited by law, and failure to disclose interests. The complainant alleges the following for the board's consideration. On May 28, 2025, the complainant was placed on decision-making leave without any prior discipline documentation or notice. The complainant was instructed to turn in all county property and disengage from operations. While the complainant was on leave, a tornado struck the region. Despite being barred from participating in the response, the complainant was later blamed for a lack of preparation. The complainant alleges that on June 2nd, 2025, the complainant was terminated by Deputy County Manager Kevin Johnson. This action violated Senate Bill 22, which grants termination authority solely to the county manager and only with the chairperson's approval when it involves department heads. The complainant has been informed that the chairperson was unaware of the termination, thereby rendering the action procedurally invalid. The complainant alleges that during a May 30th, 2025 public safety meeting, County Manager Sherry Hobson Matthews referred to the tornado response as a shit show and publicly disclosed the complainant's leave status to county directors and deputies. That the unprofessional announcement falsely suggested that the complainant was responsible for operational failures despite having been forcefully removed from the role. And as a result, the complainant's reputation and working relationship suffered immediate and lasting harm. The complainant also alleges that there was no written reprimands, performance improvement plans, or verbal warnings prior to termination. That there was informal dismissal based on subjective concerns such as tone and relationships rather than one about job performance. The complainant alleges that the termination was retaliatory in nature. The complainant further alleges that the Deputy County Manager, Kevin Johnson, has been carrying a personal firearm inside of county buildings, potentially in violation of OCGA 1611-127. The complainant further alleges the installation of unauthorized emergency lights in the Deputy County Manager's county vehicle, and that it was funded by the Emergency Management Agency resource, which also may constitute a violation of Georgia state law. The complainant further alleges that he was included in a meeting where two officers awaiting trial for murder were discussed for termination, which raised concerns about due process. It was further alleged that there were repeated issues involving William Daughtry's county vehicle usage, including over 1,200 unaccounted miles, failure to utilize the WETS fuel card, and overdue vehicle maintenance. The complainant made a written request for an internal investigation, but no action was taken. The complainant alleges that a subsequent private conversation in which Mr. Johnson confronted the complainant, implying that revoking Mr. Daughtry's vehicle was not a good look and should be reconsidered. The complainant alleges this constituted improper pressure or otherwise justified, I think there should be unjustified disciplinary action. The complainant alleges that Mr. Daughtry's commute exceeds 70 miles one way, significantly beyond the informal 37-mile limit communicated to the complainant. No corrective action was taken after this was reported. The complainant further alleges that there is disparate treatment in the application of the training reimbursement policy, where certain employees such as Jamal Scott was required to sign a reimbursement agreement that other employees did not have to sign. The complainant asserts that there is no consistent policy or financial threshold that has been applied. The complainant further alleges that there is a failure by the Deputy County Manager to initiate the required hazard mitigation plan update, despite the county having a vendor contract to have this plan implemented, and that places Henry County at the risk of losing FEMA funding. That the complainant ultimately initiated the update personally. However, it has not been approved as of April 2025. It expired. The complainant formally recommended appointing Jeff LeMaster as Deputy Director of EMA and cited different credentials that Mr. LeMaster has. However, the Deputy County Manager declined the recommendation, indicating that he was not ready, and eliminated the EMA Deputy Director position entirely, creating a Deputy Director of Intelligence role. The complainant alleges that the restructuring appeared intended to install preferred personnel, bypasses the EMA leadership input, and potentially contravene GMA/HS expectations for agency continuity. The complainant further alleges that immediately following their termination, Mr. Daughtry was appointed as director. And just to clarify for the board, this is the director of EMA. This is not an anonymous complaint. This is I should say the former director of EMA. Despite the certifications of experience typically required for the position, the complainant further alleges that the sequence of events combined with the comments by Mr. Daughtry and the deputy county manager's staff suggests that his termination was pre-planned, almost premeditated, and that other witnesses confirmed that the deputy county manager or that Mr. Williams would jokingly say, "I'm your concierge now," and that the deputy county manager would say, "You need to consider what would happen to this department if the complainant is gone," and that was all right before the complainant's dismissal. As you can see, it was a lot to unpack with this complaint. It's a lot of review. There was evidence that was provided, which were 3 different transcripts. So the complainant had a meeting with the deputy county manager and the county manager twice in one day. And then on June 2nd, I also reviewed the Senate bill that was referenced. Before I go to my recommendation, I think it would be helpful if I go back and first address this issue. So as it relates to, and I'm sorry, this issue, as it relates to termination, the complainant is correct. There is a portion of Senate Bill 22 that indicates department heads can only be fired after board approval. However, I want to point out to the board that that is not Senate Bill 22 to which the Board of Ethics is composed. It's actually Senate Bill Section 8.2 C1. And so as it relates to this portion, there is no statutory authority for the board to entertain whether or not the individual was properly discharged under the Senate Bill Section 8.2. Does that make sense? As it relates to my recommendation, we will go first with Sherry Matthews. I do recommend finding probable cause for failure to show impartiality in performing official duties. Based on the complaint itself, there were allegations as it relates specifically to cars that are being driven, employees such as Jamel Scott required to be signed an employment agreement that others were not. There were indication that there's excessive miles being put on cars where some employees are told it's 37 miles, other employees that are told they're 70 miles. And it seems as though there could be some impartiality when it comes to certain individuals within that department. So I do recommend that the board finds probable cause on failure to show impartiality in performing official duties. Any questions about this specific violation before I move on to the next?
Sorry, you're covering them one at a time, Sherry first, and then.
Yes. And I will tell you, like most of my other recommendations, this one is, to me, in my opinion, still so closely connected that it's not clear who has the authority to give certain things, whether it's the county manager or the deputy county manager. I will just go ahead and show that my recommendation for Mr. Johnson is the exact same for the exact same reasons that I'm displaying from examples. So feel free to ask any questions about both if you all like. Misuse of position, I recommend dismiss for lack of probable cause. If you all remember, this is where someone is using their position to get some unwarranted privileges or benefits for themselves. I didn't see that within the facts. Incompatible interest, this is the one when someone's accept services or rendering employment that is incompatible with their job. I didn't see that within these facts. Engaging in activity prohibited by law. I do recommend probable cause on that. there were several instances that, if found to be true, could be a violation of state law. Specifically as it relates to,
The vehicle and the weapon,
I'm sorry, ma'am?
vehicle and weapon.
Yes, ma'am. The vehicle and weapon. And then failure to disclose interest, those, we didn't have any facts. I believe that would substantiate probable cause based on that allegation.
Let me ask you a question in regards to the weapon. Could that not be part of the misuse of position as well?
Not for securing privileges for themselves.
That's
I do not
technically a
believe so.
privilege if you have lights on your vehicle.
I'm sorry.
He asked about the weapon.
No, but as it relates to lights on the vehicle, isn't that privilege? Because most folks don't have, not everyone can just drive around with police lights on their cars. We're not equipped. Is that what?
No.
No, I'm asking.
Oh,
I'm not.
okay. Okay, no, I'm trying to figure out, are you talking about the same thing I'm talking about?
Yeah, no, because you mentioned the weapon.
Yes.
The weapon in the vehicle, which was the improper use of whatever, but I'm wondering if, go back to the list, please, Dr. Tom.
Misuse position, you saying?
Misuse of,
This one?
and capable interest, engaged in activity, failure to disclose interest, misuse of position, meaning that perhaps you were given favorable services or favor in allowing you to have these lights on your vehicle.
So for me, that will be impartiality. That will be whoever authorized those lights to be put on that vehicle, being impartial, they're being impartial or not being impartial because they're giving Mr. Johnson favoritism.
Well, that's the same way I'm looking at the weapon. Because you have the authority, you have the position. That's why you can walk in with one and I cannot.
Which is why I did agree, well, to me, that is why
But
I
then-
found probable cause, or one of the reasons I found probable cause on the failure to show impartiality. Because it appears that the deputy county manager may be getting certain privileges that other people cannot.
But isn't that considered misuse of position? Define misuse of position, because if I'm in a position and I'm gaining favor because of my position,
Exactly.
that's a misuse of position. Because of the position I'm in.
Appear on his or her own personal behalf, or represent, advise, or appear on personal behalf, whether paid or unpaid, for any person before any court, administrative, legislative, or quasi judicial board, agency, commission, or committee of this state, or of any county or municipality concerning any contract or transaction which he may be the subject of, or an official at of Henry County, or otherwise use or attempt to use his or her official position to secure unwarranted privileges or exemptions for himself or others.
That's it. That's an exemption for himself.
Yeah.
We've talked about this and interpretation of this in the past. Previously, the board has only applied this when it comes to proceedings and judicial related things, or quasi judicial related things. So that's how I've been applying it. I do think it is probable cause, whether it is misuse of position or failure to show impartiality. I think it could possibly fit.
Oh.
Yes.
Well, we'll just apply it as it's written. And if it fits, then
I see it as if someone gave him authorization to do the lights and all this to the car, then there's the impartiality if someone else made that decision. But if he made a decision based on his position to get those lights put on there, then that's misuse of position.
which we don't know yet. So further investigation will provide that information, whether one or the other. All right.
And is that for Mr. Johnson or Ms. Matthews or both?
I would see it for Mr. Johnson as it relates to misuse, depending on who made that decision for those lights.
I agree, both of them could apply because he misused his position to carry the firearm. Because of his position, he knew he wasn't supposed to, but because of his position, he did it anyway. Which is the law, it's the law too, but it could be. both of them.
Now, unless there is clear authorization that gives him the authority to do so.
Yeah.
Now, I did look up the statute, and based on the face of the statute, if he has a license to permit or license carrying,
Conceal.
thank you.
Is it conceal or
If
carry?
you have that license to carry a concealed weapon, then it appears that is an exception to be able to be in that building with it. It appears.
I don't,
However, I still recommended probable cause because I felt like further investigation needed to be done on that issue.
yeah, I think there's gotta be, well, I don't know. So yeah, let's just look into it.
Yeah, that's why I wasn't too confident enough to recommend to the board no probable cause now.
So going back to Mrs. Matthews, Hobson Matthews. Did we get through all your recommendations or did we interrupt? Sorry.
No, ma'am, I believe we got through them all.
Well, I guess we, would anyone like to make a motion? It seems that we probably will have two motions, one for probable cause and one to dismiss for lack of probable cause. Would anyone like to make a motion? Or do we have further questions?
I do. Are we changing? Are we? Mr. Johnson, is it Johnson? Are we changing his misuse of position or we're keeping it as lack of probable cause?
I thought we were just, or you all were just voting on Ms. Matthews right now.
Just voting on Matthews.
It's on Matthews.
We're just doing Matthew.
Right now.
Okay, just want to make sure I'm good before I go with the vote.
Anyone like to make a motion to vote?
I'll make a motion to move with the recommendations as written.
I second the motion.
So the board moves in case 25 EB6, Ryan Morrison versus Sherry Hobson Matthews. As it relates to failure to show impartiality and perform official duties, the board would make a motion for proper cause. In the misuse of position, the board is making a motion to dismiss for lack of proper cause. As it relates to incompatible interests, there's a motion to dismiss for lack of proper cause. Engaging in activity prohibited by law. The motion is for proper cause. The failure to disclose interest, dismiss for lack of proper cause. All in favor? Unanimous. Then moving on to EB 2025, Ryan Morrison versus Mr. Kevin Johnson.
Based on the same allegations, I recommend probable cause for failure to show impartiality and perform official duties, as well as probable cause for engaging in activity prohibited by law. That is my recommendation as listed. I will say, based on the conversation and discussion for the board now, I would amend my recommendation to include the misuse of a position, hearing the rationale that the board has discussed.
Would anyone, does anyone have any additional questions or would you like to make a motion to vote?
I make a motion that we accept staff's recommendation. Mr. Kevin Johnson, with the exception of misuse of position to probable cause.
You don't want her to amend it?
Are you saying to change it to probable cause or keep it as that? That's what I thought he said, just to make sure I didn't want to.
Yes.
He amended it.
Well, she amended it to change it to probable cause.
So did he in his motion?
He amended it in his motion.
I just want to make sure he did.
Yeah,
That was my question.
I'll second that.
All in favor?
Aye.
Yes. Right, moving on here. Yes, ma'am.
Before we move on to, 2025 EB7, may I respectfully ask the board for a 5-minute break?
Yes. Do we need to make a motion for that?
No, ma'am.
Okay. 5-minute recess. Break.
Yes.
8:39. We got about 6 minutes. We'll get back at 8:45. Right, we're back. As it relates to item G, we're moving on to item G. A presentation by the ethics officer for probable cause hearing on case 2025 EB7, Nicholas Baker versus Amanda Flora.
Thank you, Chair. In regards to 2025 EB7, this is a complaint against Amanda Flora. Amanda Flora is a member of the judge. Because of that, we do not have personal jurisdiction over the matter. I am recommending that we dismiss the complaint for lack of personal jurisdiction.
Is there a motion?
I make a motion for dismissal.
Second.
All in favor? Unanimous. Presentation of item H by the ethics officer, proper cause hearing on case 2025 EB8, Shanna Parks versus Bernita Campbell, David Smith, Sherry Hobson Matthews, Holly LaFontaine, Shannon Sagnott, and Rachel Mack.
And this is in 2025 EB8. We do have personal jurisdiction over all individuals. Ms. Bernita Campbell is the executive director. Mr. David Smith is the executive finance director. Sherry Matthews, the manager. Ms. Holly LaFontaine is the human resource director. And Shannon Sagnott is the executive director of constituent services. And Ms. Rachel Mack is the county attorney. There were two allegations that were alleged, or two alleged violations. One, failure to show impartiality in performing official duty, and two, misuse of position. The complainant went on to say more specifically legal violations that they believe, which is OCGA 451035, misuse of position, OCGA 451036, failure to disclose conflicts of interest, OCGA 451038, conduct of becoming of a public official, and the place of official duty. I reviewed the initial complaint as well as the amended complaint, and as well as the response to the complainant open request. I will tell the board that I am asking for a continuation for more time. This complaint is about 111 pages. I reviewed all of it. However, because there are so many respondents, I have to review them individually for each person. This complaint, like most of the complaints that you saw, it doesn't specify one person per incident. It's all of these people engaged in all of these actions. Just to give you a little history about this case, this individual is no longer an employee. This person worked in budget and worked exclusively under the finance service department. This person was terminated and alleges that their termination was incorrect. When I spoke to the individual provided more documentation when I called and asked for courtesy of, is there anything else that the board needs to know? Yesterday, I believe, to the tune of about 7 more emails that I have not even had a chance to read. So with the board's approval, I will ask for this to be continued until next month, so I can look more into the probable cause that was presented.
I do have a question in regards to terminations. Does this factor in the at-will state for Georgia, or it's not, that's not a factor?
It is a factor. So if termination was the only reason, then that would be just a dismissal. Because again, this board cannot really hear HR issues of whether somebody was terminated rightfully or not. However, the complaint involved other issues such as a misuse of positions, whether or not upper management was compliant and fostering an environment that was retaliatory or discriminatory. I did speak to the complainant and I advised the complainant that I am concerned that there are a lot of labor law issues within this complaint. An internal investigation was conducted. The county did their own internal investigation where it was determined that it did appear this person may have been fired in retaliation. Well, as the board knows, retaliation then be considered a human resource, more labor law issue, employment issue. However, the internal investigation also revealed that although there was some hints of retaliation that gave rise to the termination, there were also performance issues which could have justified the termination as well. So it's very similar to the Court of Appeals calls it a harmless error rule that they go by, where you may find an error, but because there's something else that is substantiated, is really harmless. That's what the internal investigation revealed. But given that the complainant has provided me with more things that I need to look into for all, I believe, 5 complaints or 5 respondents, I will ask for a continuation so I can have more time.
One other question. So the complaint, the evidence that he or she is providing points to the allegations. Is that correct?
What allegation?
Her complaint.
I don't understand the question.
Is it very broad? Her complaint, is it very broad or is it narrow?
Parts of it is broad, some parts is narrow. So the broad portions are the retaliation portion and the reason that she feels that she was fired. The narrow parts are some impartiality. So I believe that other employees treat it differently than me. So that's the narrow part.
And the reason I'm asking is because she's listed so many people on this complaint that it seems to me it's like a shotgun effect that you're just trying to capture something.
And I think one of the reasons that the individual did that is because, and they were very pointed to certain evidence. All of them work in finance, so it's almost like listing the county manager and deputy manager, they work so closely together. She listed everybody from the CFO to the direct supervisor to the county manager, everybody from the head that flows down that financial service pipeline.
To include the attorney, county attorney?
The county attorney. And the county attorney, I believe the county attorney was, if I recall correctly, was in the termination week.
They've even documented in some of what I read that they do feel like there was some retaliation. The county investigation documented. Yeah.
And then they justified it by saying that because there were also performance issues, that it was essentially no harm, no foul.
Are we?
Make a motion.
Yeah, I'll make a motion for a continuance, I guess.
I would request so. And what I also do is, I believe Gloria shared the prior document. It may have been file shared because it was so big. I asked her to put new things in some type of share as well, so you all can have that prior to its meeting, because it's a lot to review.
I'll make that motion for continuance, for review of documentation.
Second.
Motion made by Dr. Kwame, second by Mr. Craig. So we're gonna vote on a continuation of case 2025 EPH, Shanna Parks versus Bernita Campbell, David Smith, Sherry Matthews, Paulina Fontaine, Shannon Sagnot, and Rachel Mack. All in favor? Then on to item I. Presentation by the ethics officer of case EB 2025 EB9, Nicholas Baker versus Gabrielle Bly.
Thank you, Chair. Right, the 2025 EB9, we do have personal jurisdiction as the respondent. It works with Henry County Animal Control. The allegation is failure to show impartiality in performing official duty and engaging in activities by law. The complainant alleges the following for the board's consideration. On June 2nd, Officer Black called the complainant to advise that the complainant's dogs were out. At that same time, the complainant was leaving Stockbridge and heading to Logan Grove. Officer Black stated she would keep an eye on the dog until the complainant returned home. As the complainant was driving through McDonough, Officer Black called again. Per the complainant, according to the body camera footage from Murfreesboro Police Department, immediately after concluding the call with the complainant, Officer Black and another animal control officer entered the complainant's gate and began detaining the complainant's 7-month-old puppies. Officer Black did one of the puppies with an unknown substance as she was bringing it out. Additionally, Officer Black had a dead deer in her truck, which she was parked in the driveway without permission. The officers broke a padlock shed on the property and detained the 3-week-old puppies. At that time, the officers were aware that the complainant was on the way home, making such actions unnecessary. It was also noted that on May 27, 2025, during a storm, Officer Black previously entered the complainant's gate without permission. At no time was the complainant giving Officer Black authorization to enter the property gate. Furthermore, the complainant's animal were not provided with any medical treatment, and the complainant was informed that the animals were euthanized if called. The complainant did not provide any evidence, but they did reference the Locust Grove body cam footage. It wasn't provided, but they referenced it. I was able to obtain the police report from that day to kind of get a better understanding of what happened, as well as talk to the complainant. My recommendation for failure to show impartiality in performing official duty, I recommend dismissal for lack of probable cause. There were no facts to substantiate that there was any impartiality. However, engaging in activity prohibited by law, I do recommend probable cause. I will be fully transparent with the board. This one I struggled with on the probable cause of engaging in activity prohibited by law, because the standard for the animal control fall under ordinary police standards. And the standard to be able to go in and retrieve or check on or detain an animal comes based solely on an officer's observation. The question becomes, what was observed that would cause Officer Black to be able to go in to even check on the animals? Now, what I do know is, in the preliminary investigation, I do know that animals were out. I do know that they did call Mr. Baker and told Mr. Baker, hey, your animals are out. I do know that there was a conversation between Mr. Baker and the officer where there was this unknown female in the car with Mr. Baker that said, hey, if you open the gate, they will go in. So there's a question of if she had permission, because Mr. Baker was in the car and never said, no, don't go into my gate. But they kind of gave permission, but she kind of wasn't the property owner to give permission. So because of that, I toggled on if there was probable cause, because if she had permission to go into the gate, then noticed that there were puppies that were in distress and didn't have water, and she at that point had enough, I believe they call it more typical, reasonable suspicion to be able to obtain the animals. What concerns me, the portion where I did believe that my recommendation is for probable cause, is because there talks about a padlock being broken. And I don't have any information about an authority to break a padlock in the court further. Now, granted, they follow the same rules of a police officer. So if a police officer can look into something and see that a body is laying there, they don't need to go get a warrant. They can get the door down. So if that individual saw that there was a distressed animal or a neglected animal, they didn't need permission. I just, at this phase, I do not have enough information to make that recommendation myself without understanding everything. Yes.
I have a couple questions.
Oh, before you ask your question, I apologize. I provided a copy of the police report in your you all package.
Okay. Is there a relationship with Mr. Baker and Bly? Do they know each other?
Do not know each other. They are well acquainted with each other because there have been multiple calls And Mr. Baker's raising it in regards to his,
Okay. Is there a complaint procedure for animal control outside of the ethics board?
Yeah. That was another reason I also struggled with probable cause. Because it appeared that his maybe suited for internal affairs. For them to look into whether or not proper procedure was made. But we have the complaint in front of us and I can, when I'm looking at what the complaint said, are alleged compared to the facts I had before me, I just didn't make a good determination that he must have been missing without an amendment.
So is the person saying that they were being impartial towards them because they would not gone into somebody else's property?
No, ma'am, I did not see that complaint.
So I'm curious, the first report we're looking at, is that a previous report?
Yeah, so the complainant mentioned two allegations. One is noted on May 27th. So the first report, which report are you looking at? Is it page 107?
I'm looking at 6/27, 6/17/25, I'm sorry. June 17th.
That's the shorter one.
Yeah, the shorter one. So we're looking at.
130?
Yeah.
Okay,
107.
There's 103 and there's 107.
yeah, I was looking at 103.
Okay, so the 103 report references,
I can stay on the 107 since that's the one you brought up first. I'll say that.
the 107 references the June 2nd incident. That is this incident, complaint. You'll see in you'll see in this report, the officers are very, very familiar with dogs. There have been multiple complaints. There are, I believe, 7 pit bulls. Theoretically, a citation should have been issued a long time ago because my understanding is you can only have 3. Or it may be 2 or 3, so he is above the limit. So the first time the officer went out, I believe in May, or it may have been this time, the officer did not actually issue a citation, but made recommendations of different resources that he could use to give, not give the dogs away, but rehome the dogs. By the time the next incident took place, that's where the dog cornered the officer, and she had to call for backup. She had to fight the dogs off. There was a lot of different issues with the dogs being aggressive. And at that point in time, that's when they took all of the dogs.
The dog that was injected with something, what happened to that man?
So the dogs are given, all dogs, not just these dogs. Or any dog can come into Henry County Animal Control, they have to be vaccinated. It's not a permission of the owner, it is a policy, so it's not to infest the various dogs they already have. So they were given their injection, the rabies, the Martella, it's a couple different vaccinations they were given.
Okay, so that was no violation per se.
No.
Okay.
Another thing is, if a dog is too aggressive for them to be able to detain, it will give them a little bit of the medicine that kind of pumps down. I don't know the formal terminology, but it's equivalent to almost putting us to sleep with this. Yes, a sedative.
Okay.
But everything that was given are things that it will not physically harm a dog in any type of way. So officer called them and tell them the dogs were out. How did the officer know the dogs were out? Did someone else call? On the June second incident,
Dispatch.
they were dispatched. Okay. On the May 27th incident, that is where my struggle. I don't know what made them go out. It says in the report why they went out on June incident, but not the May incident. It just says that the unit went out. It does say that the unit that says that I was just coming to follow up with to see if there's anything needed. So per the report, it appears that they just, officer, and it's the same officer, the officer went back out just to check in. But according to the complainant, they entered without permission.
Okay, is that? And that's what's the law pertaining to, because in other words, the female in the car gave the officer permission to open the gate to let the dogs in. At which point, the officer, at some point, it seemed, did open the gate to let the dogs in. However, in them going in, they became aggressive. Like as two were coming in, two were coming out. And then at that point, the officer was in fear of their safety. In trying to secure the dogs, which were also already being aggressive in the front yard when they arrived. So at this point, once the backup had come to help contain the animals, at that point, is that when they entered the fence to then go and get the animals? Because it seemed two came out as two were going in. So at no point was the officer not in fear of her safety.
Yeah, so it appears based on the report that at the time that backup came to help with the animals that were already loose, the command was given that we have to detain all the dogs. And because this officer was familiar, the officer knew there were other puppies. So now we have to get the other puppies too, which I believe were in the shed.
Ah, shush.
It said the shed was unlocked. One of us is the
And you can see it says, the officer explained that at this point, she had done all that she could to try to work with them to get the violation factor under control, but that the continuous escaping, chasing, and attempting attacks had to stop, and it was no longer safe for the community to have the dog at that address. Just speaking to the female, the officer went to locate and retrieve the two puppies that was said to be in the shed in the back of the property further.
So can we go revisit the complaint again?
Sure, what part?
The second one that, second part of it.
This is the first part. This is the second part.
To the body and. But it says here that she said that, did not realize until AC had advised her that the puppies did not count against him or his animal can count due to age, but regardless, no citation had been given due to the number of animals in his care. So what was his issue with this?
So his issue is that they took it off.
They were giving the dogs too, like.
Yeah, so the unknown female, the officer didn't feel comfortable actually going in the shed. I think she had a crawl under some things that were here, but that's conflicted. So the report says that she was given the dogs. The complaint says that she was in the shed, broke the padlock and took the dog. So there's kind of conflicting.
The female, the unidentified female with Mr. Baker, does she reside on the property as well?
I don't know.
Near two, it says like the animal control officer gave them food because he was low on like food. But it
Yes.
sounds like chances were given and like help was,
On May 27th, before the June 2nd incident, before they actually removed all of the dogs, it appears pursuant to complaint that here it appears that officers just came in through the gate without permission to be on the person's property. However, if you read the report says that she actually came to check on them and provided a half a bag of dog food, provided resources as to what they could in fact do with the dogs who was fed, things of that nature. So, and my understanding also is that even after this complaint has been lodged, there has been 2 more complaints about the dog. So I'm assuming you got the dog back if there's more after this. As mentioned before, the only thing that gave me pause where I erred on the side of recommending probable cause is on that May 27th incident. And it's just conflicting information. The officer said she came to check, but he said that nobody told her to go through the gate. I would say to the board that if the board does not find a probable cause, then my recommendation to the complainant is to, I refer to internal affairs and Henry County Police. I think that would be to them to see if policies and procedures were properly.
It sounds like the female stayed at the property because in the report, the statement was made that she's getting some food on her way home.
stored all.
Mm-hmm.
Can you read the Senate Bill 22, Section 7.1?
Sure. Which section? C1?
C, I guess it's C7, I guess.
C7? Engage in any activity or transaction that is prohibited by law, now existing or herein enacted, which is applicable to her by virtue of her being an official or employee of Henry County.
So that allegation would be the breaking of the lock, per se?
It appeared the breaking of the law and the entering
And
of on the premises.
pass.
Yes, but
That's, okay, good.
But let's remember, they are also governed like a police officer. So if they observe things, they don't need warrants to enter properties and things of that nature. Are governed like a police officer.
I haven't read the complete report. So did she say she entered for a reason?
On May 27th, she said that she came by to check to see if he needed anything. It sounds like it was more of a follow-up from a previous encounter. On June 2nd, she was responding to a dispatch.
So on the 27th, she entered the backyard and searched for Mr. Baker. And that's why she entered the unlocked backyard. She wasn't invited. And then on the bottom of the report, it says she told him if he needed further help to reach out to animal control. Mr. Baker did not ask why she entered the back gate, ask her to leave the property or otherwise, which indicates that Mr. Baker never invited her in. He just didn't ask her to leave.
Mm-hmm.
So she was never given a formal invitation to enter the property. She entered at her own will. And that on that particular day, there was no complaint of any animal activity.
That's why I was asking, what was the relationship? Did they know each other? Because it seemed to me that she entered and she went to look for him.
The statement that she made was, just coming to follow up with you and see if there was anything you needed. Is there anything you need? So based on the report, it appears that she tells him, I came to follow up. So there was obviously some prior encounter we don't know about. I don't know if it's like the health inspection, where they go out the first time and then they come back out to check in, or effects. I know they do that. They'll come back out and check ins.
It sounds like she was doing a follow-up check on, because at the time she mentioned, she asked him if he needed anything, but if you'll listen to the questions that she was also ascertaining information pertaining to the situation of maintaining those animals. Because she asked on if he got a fence or something to that nature, what kind of fence did he get? He talks about the wire, they talk about how high the dogs can jump. So it sounded like she did end up questioning him about the containment of those animals, as a follow-up to care as well. So it seems she could have been still in official capacity when entering the premises.
It even says she was hesitant to go all the way to the shed, like knowing what dogs are back there and all that. But she left dog food, so he happily took that, you know.
Yeah. It's a dog food.
Didn't ask her to leave.
You didn't ask her to leave.
He actually said,
I could use some, yes.
Yeah.
But it's like, it's just the law though. It's just like if someone come knocking on your door and you don't invite them in, they come in anyway. There's a law to where they stop unless they're invited in. And she technically, in her own statement, was not invited in, but he didn't invite her to, but he never invited her to come through the gate.
so I guess then the question becomes maybe more formal investigation of, once she was there, did he have a right to ask her to leave?
Yes, he did. Private property.
Well,
Now that she's in official capacity and conducting the investigation.
Well, she has to inform him that.
she was doing a
Follow-up. The police have to inform that they're
You
conducting.
still can't enter personal property without,
You can if you have articulable suspicion.
but there was no suspicion. She was just doing some hellos.
Or if there's a follow-up, a documented follow, and that's what we don't know. There's a documented follow-up.
Would they have to communicate that follow-up? If I'm here to communicate.
They don't have to communicate it, but it appears she did. Because she said, I'm here to follow up.
It appears that she was checking to see if he had corrected some violations, because he's talking about the holes, put some wires in the holes. So that seems like it was a violation.
And that's why I say it kind of reminds me, I don't know if this is good analogy or not, of a food inspector. When they go out to a restaurant and they may find violations and they give you so many days maybe to correct them. And then they come back out just to say, hey, did you do the corrections or what's the status of it? So it's really a continuation of an initial investigation.
Well, she was out there the day before. The very day before she went out, she was there. And she spoke with somebody else. It's like,
Said it took her advice and put up a wireless pet fence and collars. So apparently he was supposed to do some recommendations were left for him. It appears that she was checking on.
Attorney Bullock, I guess the activity memos, I'm looking at sheet 2 of 3, 4 of 7. The memo number, the date. That's the actual date of the report itself.
It looks like that's the day in which the memo was written. And it references, so it's written on June 17th, but it references the incident of May 27th.
So the other one references 6/3
Huh?
and the event happening on 6/2.
Yeah. So it just looks like the day they actually was able to get the documentation done for the event that took.
I think I would need more understanding of what rights she had to enter the property for the follow-up. It is because of the he said, she said, we just get her information to have priority. Make sure there is not a violation. Maybe. What do y'all think?
Whole taking of the dog, but I think at that point you're invited. Like you're accepting a gift. Like if you don't want somebody there, you're not going to accept a gift. You're going to be frustrated with them and standoffish. That makes sense. That's my only thing with the whole like frequent flyer program kind of, I feel like she knew we're not to go in the yard because of the dogs, all that sort of stuff. It's just my thought.
Just depends on what the law says.
She went there the day before and she knew that he had too many by state law. She got caused.
Yeah.
See, I don't understand the law enough. I would need more clarity.
Well, he even admitted, Mr. Baker says he knew he couldn't have that many per state law.
Yeah, he stated that.
Page 2 of 3, it's probably the third paragraph from the bottom kind of takes off in there. ACH stated that on 5/26, the male she made contact with stated that he had the 4 S27s that were outside, which were seen on a video cam, as well as a female pit type with 3 pups inside on the shed. Nicholas confirmed that he did in fact have 7 27s in total and that he knew that he could not have that many per state law.
Gotcha. Thank you.
So that seems like that gives her some authority to be there.
As a follow-up.
Yeah.
Yeah, because she's talking about being in close proximity.
So even though she's following up, does she need to have permission to go in?
My
Even though it's a
understanding
follow-up?
of, police officers in general is, once there's an investigation, they can follow up and continuing for the investigation.
So if it was, so the outside of a property fenced in is considered the same as inside. So on a follow-up to an investigation, if a person were to answer their door, could the police say, hey, we're gonna answer these questions inside, and that person refused and say, hey, I'll step outside and talk to you? Can that not happen? Is that they have a right to enter the property even without invitation? I don't think that's true.
I don't know.
Because then that would be considered the same as a fenced-in yard.
I'm gonna make a recommendation. Is there an internal review for this department?
Yes, they fall under police.
Can we make the recommendation that they look into this as far as internal review? That would be my recommendation.
I think I would agree.
A dismissal of probable cause on all counts with the recommendation that it be referred to internal affairs for further investigation.
Yes, I agree.
They can see the camera, all that,
I
everybody.
agree. All righty, so you guys ready to make a motion as it relates to item I, presentation of EB 2025 EB 9, Nicholas Baker versus Mario Bly, as it relates to failure to show impartiality and perform official duties. And as it relates to engaging in activity prohibited by law, would someone like to make a motion pertaining to the 2 items individually or together, altogether?
I'll make a motion altogether. I would say that I would make a motion to strike the probable cause in the second bullet, make it lack of probable cause, and with that motion, recommend assign it to internal review so we can further look at it within his animal control.
Or internal affairs. Internal affairs.
Anyone like to second the motion?
I'll second.
All in favor? All except for Mr. Lee. Mr. Lee. Mr. Lee. Everyone else is in there. As relates to item J, presentation by the ethics officer of probable call hearing on case 2025 EB10, Nicholas Baker versus Mary B. Austin.
Thank you, Chair. Right, the 2025. Nicholas Baker versus Derek B. Austin. This stands on 2025 EB9. If you remember, and if you review the report, you saw that an officer accompanied the animal control officer out there. That was this officer Austin. It is the chief of police for the city of Locust Grove. My recommendation is dismissal for lack of personal jurisdiction.
Anyone like to make a motion?
Just a point of clarification on that. Jurisdiction, what are we talking about here as far as county or city? I got it, okay.
Motion that we accept staff's, the ethics officer's recommendation for dismissal.
I see.
Lack of personal jurisdiction.
Second by Dr. Rame, all in favor? It's unanimous.
Chair, with the conclusion of 2025, you can share that concludes all of the things that I have with the board.
All righty, I move the motion that we as a board, I motion that we as a board go into executive session.
So.
And to include staff members, the ethics officer, as well as the ethics administrator.
Sorry, who's that?
Who's second?
That's it.
All in favor?
Aye.
All right, I'll make a motion to come out of executive session.
Okay.
All in favor? We are now out of executive motion, executive session. Is there an announcement to amend the agenda by adding any items?
There's motion for amendment. I would like to resign nomination for chair. I'm sorry, for vice chair.
Is there a second?
Second.
All in favor? It's unanimous. At this moment, we're gonna return to item M. I know I added item M behind behind B and before C. We're gonna return to item M to vote for chair, a new vice chair. Is there any nominations for that position? I nominate Mr. Lee.
Motion, we close the nomination on set of one name.
Say it again.
Offer motion that we close the nominations on the set of one name.
Okay. Do anyone second that motion?
Second.
All in favor of Mr. Lee becoming vice chair of the Board of Ethics? At this moment, if there are no other items, I will adjourn the meeting. Motion to adjourn the meeting.
Second.
In favor?